Actually, his resignation has not been entertained by the authority.
Milord,
So against that, we have filed a writ application.
with your
Mr.
lordship,
Jishnu-
with your
Jishnu-
lordship, with your lordship's leave, Milord, I am with my learned friend. What has happened is I want to Milord, I want to contest the elections and I want to file my nomination. But before that, I must retire from the railways. So, Milord, I resigned. I sent my letter of resignation. Immediately, Milord, upon the railways coming to know that I would contest the elections, what has happened is they have rejected my, Milord, resignation. So, Milord, and they've started a show cause. They've given me a show cause and started a disciplinary proceeding. So, Milord, I'm challenging that before your lordship. If your lordship permits it to be listed on Monday, I will come physically, Milord, and do the matter.
Monday it will be tough, Mr. Chaudhary. We can have it on Wednesday.
Milord, this is the last date.
Actually, every
So,
day, Milord, is
It can be any time on Monday, my lord.
Monday won't be possible. I have too many matters on Monday.
Milord, in that case, tomorrow,
Wait a
Milord, if your
minute.
lordship permits.
Not tomorrow.
Tomorrow the holiday.
Suppose the 27th
We'll have it
is
on-
the last day. And if your lordship allows, there must be conclusion of the disciplinary proceeding, Milord, before the.
It can't be done in one day, Mr. Chaudhary. You also know it. I'm not, but we'll see it.
Monday, my lord, any time, my lord.
Milord, any time, Milord, for 5 minutes. I promise not to take more than 5 minutes.
Monday, I have too many matters on Monday, Mr. Chaudhary. Monday won't be possible. We'll have it on Tuesday.
Tuesday, Milord. And I will,
Grateful, my
Milord,
lord. Grateful.
I will take advantage of your lordship's kindness and mention a tender
Can it be
matter
the-
also, Milord.
Monday. Tuesday. will be. Tuesday.
My lord, Tuesday, my lord, can it be in the top of the list?
No. We take all the matters.
Grateful, my lord.
Be grateful to your lordship.
It's a new motion, mentioned about Monday. Yesterday I mentioned probably meeting order, but after I from that matter has not been listed because the record is lying in the copying section. Actually, tomorrow is my last paper.
The record is lying in the copying section. You have to get the record. Yeah, what are we? Get the copying section. You go to the copying section. Tell them to send the file. Chase the file, madam. You have asked for a certified copy. So you have asked for a certified copy.
No, not me. Actually, other respondent Union of India.
Reply has been filed in this matter. Reply has been filed. What is the matter about?
One regarding one suspension of staying there. We got a stay for 6 weeks, and the Union of India filed appeal.
So you have challenged the tender.
That is defective. That from 16th it is listed, and that is showing defective. So there is no chance for early hearing. And defective probably on the ground of certified copy. And they have asked for certified copy. So let's see that.
So you have challenged the tender process, right?
Yes.
There's a stay on the tender.
No. They have cancelled my. They have cancelled my position, and I have. The court has already stated that in order. They have stayed me for participating.
Requisition bill. If the
Milord, may I be permitted to mention a matter for inclusion in the list? Milord? It's new motion.
inclusion in the
Milord, it's new motion. File the matter.
new motion.
Yes.
Yes.
Milord, mention matter, new motion.
Am I running away? What's the hurry?
Leave to file one writ petition on an urgent basis on the basis of Rule 26 of the appellate side rules, your lordship. The difficulty is that, your lordship, the petitioner, who is a primary teacher, school teacher he is, your lordship. When he was on a medical leave, your lordship, one order of transfer has been passed and that has not been communicated to him, your lordship. What
Whatever
has
it is.
happened, your lordship, that he has been
File it.
communicated at the verge of his
File it.
your lordship,
No,
kindly
no.
keep this matter on Tuesday
No.
at least, your lordship.
No.
Otherwise, the petitioner
File it,
would,
mention it.
your lordship, the difficulty is that unless the
Whatever
matter.
it is, Mr. Charya, file it. mention it.
Lordship, may I permit to mention one matter under the heading motion, Lordship. On 22nd of December, Honorable Justice Amrita Sinha directed the respondent authority to pay the amount, Lordship, and list the matter on February, Lordship, in the month of February, but till did not appear, Lordship.
We'll see that later.
Lordship, already matter directed, the only report will filed by the
We'll
respondent.
see that later.
Lordship,
Mention one matter for correction in the order.
Whose order?
Your order. In the itself.
Give, to be
Lordship, may I
mentioned,
permit to mention.
to be mentioned tomorrow. What is the correction?
Mention for.
Mention the correction in the order.
Maybe.
Lordship, may I permit to mention, actually, Lordship, is in the motion stage. Lordship, state is direct to file a report,
Not
Lordship.
right now.
Lordship.
Yes.
Permitted to mention my lordship. It's in the motion.
Sorry?
Lordship, may we permit to mention matter? The matter relates to electricity, Lordship.
New motion.
No, Lordship.
Wait.
My lord, new motion matter. My lord, may I permit to mention, my lord, one application, my lord.
Application for what?
My lord, application of, my lord, there is a motion is pending, my lord,
Not right
and
now.
subsequent, my lord, kindly
Not
consider,
right
my lord.
now. Yes.
Hearing matters, your lordship, affidavits have been exchanged and it's ready for hearing.
Not right.
Your lordship, on
What are these matters?
Lordship, I'm just seeking for condemnation of my application where 119 2B application was rejected by the income tax authority. I just want to file my returns for it.
You want to file your returns?
For that, my delay wasn't controlled.
Give it.
Lordship,
Maybe
we have
permitted to
permitted
mention
to
your
mention- motion, your lordship, wherein the petitioner here is a mother and is being aggrieved by the non-payment of the compensation on the son's death. And your lordship, the state was said to was directed for to provide an affidavit in opposition, but was it's not provided till then, your lordship. May I be permitted to mention the motion?
Your lordship,
to
mention
your
your
lordship, one motion matter, your lordship.
What is the issue?
Issue is regarding not payment. The
Non-payment
petitioner
of
was
what?
allotted- The petitioner allotted the work to set up polling booths.
Wait, contractual.
May I permit to mention, your
Yes.
lordship. Actually, it's a motion stage, your lordship. There was a direction for the state to file a report.
What is the issue?
Issue is, your lordship, the despite of full payment, despite of full payment, the electricity has not been done by the electricity board to the school. There still remains unrestored.
Electricity.
Yes, grateful.
Lordship, if I will be permitted to mention another hearing matter, your lordship, it's a 129 issue where
Not right now. You had enough.
But I am asking the lordship, tomorrow, probably will be the holiday.
How do you know? Tomorrow is a holiday. There was no moon was sighted in Saudi Arabia. So how do you know?
You know, tomorrow is my last day, like, I am asking.
I cancelled my ticket. Tomorrow is not a holiday. Who says tomorrow is a holiday? No moon to be sighted, madam, in Saudi Arabia. How do you come to this conclusion? Saturday is, I think, probably will be on Saturday.
Lordship,
Only 5% chances that it will be seen today.
lordship, on any day next week, your lordship. On any day next week, your lordship.
This one, no, not right now. Yes. Motion matter. Wait.
Item number 1.
This is a contempt application, Lordship.
What is the contempt?
Lordship, Lordship's order is at page number 16, Lordship. This is a illegal construction allegation against the private respondent. Respondents were directed to consider the representation of the petitioner within 8 weeks from the date of communication of the order. The Lordship, thereafter, the order was communicated at page number 19, Lordship, on 23/6/2025. Thereafter, Lordship,
Who is appearing?
Lordship,
Somebody is appearing.
Lordship, this is the first.
If somebody is here, I know not appearing, but somebody is here from the, who appears generally, who's the lawyer concerned?
Lordship, in the writ petition, I had appeared on behalf of the state.
Take notice this also, file your compliance report.
Lordship.
Give a copy of the contempt petition.
It
The
has-
present petition has been prepared by the petitioner alleging willful and deliberate disobedience of the order passed by this court dated 17/6/2025 in WPA number 1221 of 2025, titled Manoj Kumar Gaur versus State of West Bengal. Full stop. Mr.
Lordship,
Sumit
I am
Kumar.
being led by Mr. Shubir Kumar Shah. learned
You are
agent.
Mr. Sumit Kumar.
Yes.
Mr. Sumit Kumar, who was present in the court and had appeared in the writ petition, is directed to file, seeks and is granted. How much time? File your compliance report.
Lordship, there was, out of the court, Lordship, there was a disciplinary proceeding which has been carried out against the concerned PDO. But
So somebody must be there, right?
yes, we require certain time, Lordship, in this matter.
Seeks and is granted 2 weeks time to file compliance affidavit.
Lordship, 4 weeks.
Compliance affidavit, 4 weeks is too long.
4 weeks, Lordship. Because due
Compliance
to
is
the
too long.
ensuing elections also, we are having problems towards communication of this.
4 weeks time to
4
file
weeks time.
compliance affidavit.
Grateful, Lordship.
A copy of the the contempt petition is handed over to the counsel for the respondent. List before the next available circuit bench. List after 4 weeks before the available circuit bench. Give a copy of the contempt petition.
Lordship already handed out. Yes, with them.
Item number 2.
Yeah, please, your lordship. Lordship, I'm filing my affidavit of service. Lordship, similar matter has already been disposed of by the coordinate bench by the order dated 25th of February 2026. I'm handing over the same order.
What is the issue?
Lordship, my vehicle was seized by the forest department. I have made a representation that the appellate time has been over, and due to my ill health, I was not able to. I have made 2 representation on 29/8/23, 19/8/24, but never ever anything was responded. I just want to respond the matter before the proper authority. That is the only direction I'm seeking, lordship. Annexure 2 is my first letter, lordship. At page 14, 1-4.
One four.
1-4. The appellate time period is 30 days. So I was ill, and by that time the first appeal is lying in the district court. So district court was, by that time the bar was on strike mode. So I was not able to anyway. So after that I have made so many representation, one at annexure P3, that is on August 23, and the next representation is at 19th August 24, that is at page 17. None of them was responded. I am not entertained anyway. So I just want to represent my case before the proper authority. And that is the direction I'm looking for, praying for before lordship.
This judgment is not applicable in your case.
Which judgment, Lordship?
The one you have.
It's a similar matter, Lordship. Only the petitioner name is changed, nothing else.
Not the when was the vehicle seized?
She did FIR 41 in the complaint. So this was 20th August 21.
20th August 2021.
Seizure list is made on 20th, but seized on 22nd August 2021. First order of confiscation order was at annexure P1 at page 10,
When was this order passed?
17/3/2022.
What were you doing since then?
Lordship, before that, I have given a letter that has been properly
Show
accepted.
it, sir. Show it from the.
At P2, Lordship,
Just a minute.
P2 at page 14, that was received. The seized word which I have explained before your Lordship, I have been specifically marked at paragraph number 4 in my writ petition.
After this order, what happened?
I have given a letter, annexure P2 at 14.
Yes.
Thereafter, my representation is at page 17. Lordship, 15 first. That is annexure P3. I have not answered. Then again, I have made a representation at page 17, annexure P4.
The order was an appealable order, right?
Lordship,
Who appears for the state?
never. Even in last matter also, Lordship can observe that nobody has
Who
appeared.
appears for the DFO? Just see Mr. Rahman, who will appear?
I'm inquiring, just it will take 2 minutes. Please,
Just give a copy. Come back.
I have already supplied, Lordship.
All right, come back tomorrow.
Tomorrow.
In the meantime, we'll find out, please.
Find out.
Good.
Lordship, similar matter order has been already passed.
Similar matter, I will not follow the similar orders. All right, I'll see the merit of the matter in this.
Lordship, similar, same or affidavit service can be taken on record. Oh, achha. Great.
What is your name? Mr. Kundu? What is Abhishek Sarkar? We will see the merit of the matter. Don't push this court.
No, Lordship, kindly consider the merit of the matter is same.
I will consider the merit of the matter.
Both the vehicles has been seized on the same very day.
And I'll dismiss it also if you push me like this.
Lordship, we can push for our clients only, not for my any benefit,
You will
Lordship.
see the benefit where the matter is there
Very well, very well.
tomorrow.
As you Lordship, please.
Item number 3.
The Lordship, in this matter, actually, what happened, the senior counsel will come from Patna and he'll do the matter. Lordship, he's supposed to come on virtual mode, but some technical issues, he could not be able to join this court. Kindly fix on Monday or Tuesday, any day. It's a GST matter, Your Lordship. Actually,
Who's the lawyer who's coming?
I am the advocate on record.
Tuesday.
Grateful, Your Lordship.
Next.
Item number 4.
I for the petition, my lord. Your lordship, yesterday, my lord, your lordship has already gone through the facts probably, my lord. senior citizen matter, my lord. কোনটা বলুন তো? দুজন। হ্যাঁ আছে বোধহয়। হ্যাঁ ওই ছেলে মেয়ে সব।
Yes, sir.
Your lordship, your lordship primarily focusing on whether the lord
Yes.
read court can my lord kindly come to section 16 of the my lord senior citizen act, my lord.
You have another copy? I'm sure we don't have one. Senior citizen. I don't think so.
Section 16, my lord. Section 16, my lord.
Appellate tribunal,
Yes, your lordship.
it's an appeal from the tribunal.
Tribunal, yes, sir.
So you go to the appellate tribunal.
Lord, I cannot, Lord, because the non-senior citizen cannot prefer the appeal before the tribunal, Lord.
Non,
Non-senior citizen cannot file senior citizen, Lord, cannot prefer an application, cannot file an appeal with DM, Lord.
yes,
I'm for the response number 4.
I didn't follow you.
Lord, the appeal I cannot file, my lord. In the tribunal, my lord, I'm in the tribunal, my lord, I'm the respondent, my lord. I'm not aggrieved, my lord. That if the senior citizen want to prefer appeal, the petitioner should have come with the appeal before the
Anybody can
district.
file an appeal.
No, my
Anybody is
lord,
agreed by the
no.
order.
Section 16 specifically says, my lord, only senior citizen can file appeal, my lord.
Any senior citizen or a parent.
Parent, my lord.
Who are you?
This is the reason, my lord. I am,
Arey, who are you?
my lord, respondent, private respondent is my brother-in-law.
Private respondent is your brother-in-law.
Yes, your lordship.
And what has happened? Where's the order?
Lord,
Tribune order.
Facts, may I emphasize the facts,
Yes.
my lord? My lord, kindly come to the order dated, my lord, first.
You tell me the facts, yes.
Fact is that, lordship, that the entire property belongs to me initially, and I have given the property to my own daughter. Now what happened? Lordship, I by profession a blacksmith. Now what happened? The opposite party, the petitioner herein are the permissive occupier in my property, being a relative. Now what happened? They, after demise of my wife, I have been subjected to tremendous torture, and they have made me sure that to stay at my own shop instead of my own house. Lordship, this is going on for years. Ultimately, we managed to get into the room of my house, and subsequently they renewed their torture. Not only that, all the gold items of my shop, which my customers had given to me for repairment and all, that has been taken away. I approached before the magistrate. Magistrate directed the police to recover the same. On the basis of that, they were arrested. The petitioner were arrested by the police. Thereafter, the entire gold ornaments and the items were recovered from their possession. Subsequently, that was released to me by an order of the magistrate. So what happened? Subsequently, out of grudge, they are renewing their torture to not to possess of my land and to stay at my home. Therefore, I approached before the magistrate and got an order that not to disturb with my peaceful possession, because I am the occupier, bona fide occupier, and since I have technically gifted my property to my daughter, they are married, they are not residing, so I should be remain alone in this property. This is the whole thing. There is nothing to be prejudiced by this order, because the order impugned, they have stated there is nothing prejudicial, because they have no title. Now they are merely staying on the basis of a permissive possession. So the writ petition itself is devoid of any cause of action.
May I, my lord?
Yes.
The facts of the case, my lord, what my learned friend is Nat and my lord, is the civil dispute, my lord. They have preferred a title suit against me. We have also preferred title suit against my
You're
lord.
the daughter.
No,
You're
no,
troubling your
They are not daughter.
I'm
They are
the
not daughter.
brother-in-law, my lord.
They are my brother of my wife.
Brother of your wife.
My wife
Yes, my lord.
and their family. They have no locus to stay here. Despite the same, they are occupying the property.
These facts will be delivered, will be dealt by the learned civil court, my lord. We have filed the title suit. They have also preferred title suit. Lord, kindly come to the, my lord, page number, order, my lord, page number 55. My lord, then I will come to their petition, my lord. Kindly come to page number 55, annexure P7. And initially, their prayer was rejected because that petition does not come under the Senior Citizen Act, my lord. Necessary portion is page number 56. Relevant portion, page number 56, first paragraph. Yes, your lordship. দাদা সিনিয়র সিটিজেন বই দিন না, আমার তো ভুল এগারোটা তাই না, আমরা লাগবে তো দর্শককে দেখাতে হবে। সিনিয়র সিটিজেন 2007, মেইনটেনেন্স অফ সিনিয়র সিটিজেন, এটা বলেছেন না, ওয়েলফেয়ার অফ সিনিয়র। Maintenance and welfare of parents and senior citizens. Maintenance and welfare of parents and senior citizens. 2007. Maintenance and welfare. Maintenance and welfare of senior citizens and parents. Of parents and senior citizens. 2007.
This is the order you
No,
you
my
agree
lord.
with?
No, my lord.
Then
My lord, this order was passed, my lord. My lord, your lordship also come to the, my lord, the petition, my lord, page number 44, my lord. I am coming to, my lord.
which is the order you agree by?
I am aggrieved by, my lord. My lord, this order was passed initially, that prayer was rejected. It was civil dispute, my lord. Subsequently, they have made a put up petition before. After it has been, my lord, kindly come page number 60.
Order dated 17th of November 2025.
Page number?
Page number 60. They are primarily aggrieved of order dated 17th of November 2025. According to their contention, they have been deprived
Well,
of right
subsequently,
of
page number
hearing.
61 also, my lord.
But the fact is that since they were heard of
Well,
and the specific order
after
was
the petition was dismissed,
let sorry.
put up petition was allowed, my lord. How it can be, my lord? Put up petition they given.
No, they were heard of.
Please follow, bhai.
Let the court peruse the order, then I am submitting.
My lord, then page number 61.
Yes.
But my
Kindly
humble
come to
submission
page
is
number
that-
44.
Sorry.
Lord, kindly come to page number 44. Their petition.
Page number 44.
Yes, your lordship.
No page number 44 here.
Yes, your lord. Lord, kindly come.
Not here.
Your lordship.
After 43, it's 45. No, wait. No, no, it's here. Yes, page, yes.
44 minutes. Lord, kindly come, my lord, the petition under section 21 of Maintenance and Welfare of Parents and Senior Citizen Act. Lord, kindly, my lord, if your lordship kindly, section 21 of the my lord, book Senior Citizen Act, my lord.
Can you see the prayer first? 46, page number
Lord,
46.
kindly
prayer.
come.
Yes.
My lord, let him
Prayer
complete, my
portion.
lord. Let him complete, my lord. I will not, my lord, I sit down, my lord.
Let it.
Lordship.
If he, Lord, kindly come to, and even section 21 of the book, my lord. If they at all can clear the petition before the senior citizen, my lord, this is a complete, my lord, abuses of, my lord, sections, the Senior Citizen Act. Who can file the act petition before the senior citizen, under senior citizen before the tribunal, my lord? Kindly come to the book section 21. Does, my lord, section give any power to file any petition under section 21? Now, throughout the act, my lord, it is only maintenance to the parent and, my lord, the welfare of the senior citizen who are supposed, the illegally are supposed to get the benefit of the property. If the senior citizen dies, my lord, then their property devolved to someone and only that person will get the benefit. Or for this reason, their senior citizen is supposed to get the maintenance. My lord. This is the whole context of the book or act of, my lord. Your lordship, if you go throughout the act, my lord, your lordship find that, my lord.
21 doesn't specify that.
21, my lord, saying, my lord, nothing. 21, how can they come under 21, my lord?
That's all right. That's the wrong section they mentioned.
Wrong section, my lord, they have no locus to file this petition before
Why
the
they have
transit
no
court also.
locus?
Yes, your lordship?
He's a senior citizen, he can file a.
No, my lord, no, absolutely not.
Why?
No, my lord, kindly come to the, my lord, Inter-Citizen Senior Citizen Act, my lord. It's, my lord, kindly, my lord, I don't have the book, my lord, I cannot refer your lordship, the sections, my
Get
lord.
a copy, get a book. Pass over.
My lord, kindly make it not to the end tomorrow.
Why?
Make it not to the end, my lord.
I've heard you, we'll finish it off.
Yes, your lordship. My lord, kindly speak, my lord, at 12:30 or, my lord.
Why?
Why will go, my lord, your lordship will be,
Stay here, sit here.
well, I have to division bench matter also.
Go do your division bench, come back.
Yes, your lordship.
कितना टाइम लगता है क्या टाइम का? How much time it takes? इतना टाइम क्यों लग रहा है? Wait, I'll dispose it off.
Yes, your lordship.
Section 5 করতে হবে।
My lord, kindly come to 4, my lord. Section 4. My lord, section 2, my lord, the definitions, my lord. Minor, relative, welfare, my lord. My lord, in definition to welfare means, my lord, what they have also indicated, my lord. What was welfare? It means, my lord,
So
food.
he's a senior citizen. Are you disputing?
He is senior citizen, my lord, but he don't have the locus to file this, my lord, under this
Any
section.
senior citizen has a locus. to
No, my
file
lord,
any
cannot
record.
be, my lord. Kindly come to the section 4, my lord.
Yes. What do you mean cannot be?
No, cannot be, my lord. This
Why?
section, this law doesn't permit him, then I'm the brother, he's the brother-in-law. Lord, he can claim maintenance if he entitled. If he wanted to, my lord, kindly come to what is, my lord, maintenance of and parents and citizen, my lord. Section 4.
Yes.
My lord, kindly say entire section, my lord.
Read it. You are
Yes,
the
your
one who's
lordship.
saying.
Yes.
Earning or property.
A senior citizen, including who is unable to maintain himself or his own earning or out of property owned by him, shall be
Senior
entitled to.
citizen, including parent.
Yes, your lordship.
Yes.
I am coming, my lord. A senior citizen, including parent, he is not parent, my lord, senior citizen only. Unable to maintain himself from his own earning or out of his property owned by him. Lord, yes, your lordship, and shall be entitled to make an application under section 5, my lord. Well, what, in case of parent, grandparent, against one or more children, not being minor, my lord, against whom they can file, my lord. A childless senior citizen against such relative refer to G, section 2. The obligation of the children or relative, as the case may be, to maintain a senior citizen extend to the needs of such citizen so that senior citizen may lead a normal life. Fine. The obligation of the children is 3. Obligation of the children to maintain his or her parent extend to the needs of such parent, either father or mother or both, as the case may be, so that the parent may lead a normal life. 4, my lord, any person being a relative of a senior citizen or having sufficient means shall maintain such senior citizen provided he is in possession of the property of such senior citizen or he would inherit the property, my lord, of such senior citizen, my lord. Is in possession or inherit the property. Provided that while more than one relative are entitled to inherit the property of a senior citizen, the maintenance shall be payable, maintenance, my lord, shall be payable by the such relative in the proportion to which they would inherit the property, my lord. Maintenance, my lord.
May I give the reply?
Well, after we conclude myself, my lord.
Yes.
Yes, your lord. Like only maintenance, my lord. My lord, kindly come to section 5.
Yes.
Application for maintenance, my lord.
Not only maintenance, anything. That's your reading. That's wrong.
Anything means, my lord, anything, my lord, entitled to inherit the property, my lord. I'm not inheriting his property, my
Not
lord.
only entitled to property, even any relative who is read for any person being a relative of a senior citizen and having sufficient means shall maintain such senior citizen provided he is in possession of the property of such senior citizen or he would inherit the property of such senior citizen.
I'm not inheriting his property, my
You are
lord.
not inheriting.
No.
You are there in the property.
No, my property, this is a disputed fact, my lord.
No.
This,
Disputed
my lord,
fact,
let him say, my lord, whatever he indeed.
disputed fact we'll see later. And no agitation in
My
my.
lord, he is
I'll throw
continuous.
you out.
Yes, your lordship.
Don't
My
show
lord, he is
agitation.
continuously inputting, my lord. I am making a
You argue
submission.
your matter.
Yes, your lordship. My lord, kindly.
Either raise your voice, no agitation in this court.
Yes, your lordship. My lord, kindly, my lord,
Keep
paying
the
apology.
decorum in the court.
Apology, my lord. My lord, kindly come to section, my lord, paying apology, my lord.
Not in my court. Don't do these dramas in my court at all.
Yes, your lordship. Paying
Argue
apology.
the merit on merit. No dramas.
Yes, your lordship. My lord, kindly come section 5, my lord.
Yes.
An application for maintenance under section 4 may be made by a senior citizen or a parent, as the case may be, my lord. Senior citizen or parent. If he is incapable or any other person or organization authorized by him, the tribunal may take cognizance suo motu, my lord. Tribunal takes suo motu, my lord. Senior citizen, my lord, in this case, my lord, senior citizen or parent, as the case may be. If he is incapable, my lord, by other person, organization authorized by him. My lord, explanation was given. My lord, 2. The tribunal may, during the pendency of the proceeding in monthly allowance to maintenance under this section, order such children or relative to make monthly allowance for the interim maintenance of senior citizen, including parent, to pay same to senior citizen, including parent, as tribunal may. This is a maintenance issue. On receipt of an application for maintenance under subsection 1, after giving notice application to the children or relative, after giving parties the opportunity of being heard, to hold an inquiry for determining the amount of maintenance. An application filed under section 2 for the monthly allowance for the maintenance and expenses of our proceedings shall be disposed of within 90 days from the date of service of notice of the application to such person, provided that the tribunal may extend the said period once for a maximum period of 30 days in exceptional circumstances for reasons to be recorded at England. All right, my lord. An application for maintenance under section 1 may be filed against one or more person, my lord, provided the children relative may impede the other person liable to maintain parent, maintenance, my lord, to application for maintenance. While the maintenance order was under against more than one person, the death of one them does not affect the liability of others to continue paying maintenance. But any such allowance for the maintenance or exception for the proceeding shall be payable from the date of order. This is the, if children or relatives so ordered fail without sufficient cause to comply with the order, tribunal may, for every breach of order, issue warrant levying amount of due in manner, provided if for levying fines, may sentence such person for the whole or any part of month allowance for the maintenance and expenses proceeding, as the case may be, remaining unpaid after the execution of warrant. Well, this is the, if they are not paying the execution warrant issued. Provided no warrant shall be issued for the recovery of any amount due under the section unless application be made to tribunal levy such amount within the period of 3 months from the date of. Well, this is only maintenance amount. Well, then come, your lordship, come jurisdiction. Section 6, jurisdiction. The proceeding under this section 5 may be taken against any children or relative in any district where he reside or last resided, where the children or relatives reside. But this is the where on receipt of the application section 5 shall issue process procuring presence of children or relative against whom the application filed. For securing the attendance of children relative tribunal shall made a power judicial magistrate first class as provided under the section. Jurisdiction and procedure, my lord. The whole section is for maintenance, my lord. And this particular this code initially pass an order that this petition is not maintainable because there is a land dispute between them. Well, after disposing a case, well, can a court again pass an order on the same case?
Yes.
Yes, Lordship. Let him reply, my lord, then I will, if necessary, my lord. But your Lordship already gone through the, my lord, orders, my lord. This is the 55, my lord. Your Lordship has gone 56, the relevant portion where the learned tribunal said, my lord, that this is the dispute, private property dispute. The Senior Citizen Act does not come, my lord. And section 50, 60 and 61, my lord, on the basis of after disposing the same, he take up the matter, page number 60 and 61, and pass an order. And the other issue, my lord, whether he is entitled or not. And another portion, the property belongs to the daughter, my lord. And whether she can file, my lord. Well, I am not the daughter, I am not the children, my lord. Private opposite party is only, my lord, the brother-in-law. No, I am paying apology, my lord. I have raised my voice again, my lord.
Yes.
Yes, sir. So the entire list comes in consists of 3 sets of order. First order in respect of the purported application under section 21, where I have the petitioner has sought for only a prayer before the SDO magistrate direct the IC police station to ensure proper safety of the petitioner so that he can enter and live in the house and take stern legal action against the OP and his agent to protect the life and property. So only protection order I sought for, against which the learned magistrate was pleased by an order which is available at page 56 of the application, where the learned magistrate was pleased to hold that since the dispute is nature of property dispute per se, therefore they are not going into the matter. Therefore, the prayer that prayer was not dealt with effectively, and accordingly accordingly an order has been passed wherein it has been categorically held by the learned magistrate that the case at page 56. Kindly see the first paragraph, that the case is related to a taking possession of the dispute and structure thereof which does not comes under the purview of Maintenance and Welfare and Parents Act 2007. Both the parties are directed to approach before the court of law for redressal. Now, in this given situation, I would submit, Your Honor, that there is an existing title suit is pending by and between the parties. I'm not going into the matter. Even the court, the magistrate has not gone into the matter. They have relegated the parties to go for a suit court to adjudicate their issues. Now, there is no harm, there is no prejudice. Now, when thereafter, at page 57, when an application was filed for search warrant against the petitioner herein, pursuant to the execution of the search warrant under section 97 of the old Code of Criminal Procedure 1973. On that particular provision, search warrant when executed, then the particular gold ornaments that has been taken away or theft away by the petitioner was recovered. Even after arrest the petitioner. Thereafter, at the next pair, at page 58 of the application, that it has been stated that that Dilip Roy, he is the petitioner who has been released on bail. On the next order, 23rd of May 2025, by this order, that particular seized gold ornaments were handed over to me. That was done under section 97. Now, this is the end of the story. Now, what happened? One put-up application was filed at the behest of mine. Now, that petition was on this particular put-up petition, the learned magistrate had passed an order on 17th of 11/2025. But your lordship had perused in details. There are 6 orders. None of the orders are prejudicial to the petitioner because there is no order of eviction. Number one, in terms of in the scheme of the Senior Citizen Act. So the Senior Citizen Act directly, there is no order which has been passed under the scheme of the Senior Citizen Act. Now, this particular order, 17th of 11/2025 itself, particularly, I'm repeating the order, the direction only. The opposite party are hereby directed not to create any obstruction, hindrance, maintain a disturbance when the petitioner enters into his residence in his own house and necessary needs for house. So I belong to the house. This is my property. Me and my daughter are reside here. Though my daughter is a married, so since the opposite party or the petitioner herein are disturbing continuously, the magistrate are directed not to disturb the peaceful possession. So there is no harm. Number one. Number two, the second direction, the petitioner is allowed to enter my own house as and when required. So that particular direction has allowed me. So there is no prejudice to the petitioner. Now third, the opposite party are directed not to disturb or interfere with the petitioner in any manner. So I, being a senior citizen, or not even the senior citizen, a citizen, he is entitled to get a peaceful possession on his own property. So this is the no harmful, no innocuous, no harmful order has been passed. Now fourth direction, IC Alipurduar is directed to take all necessary measures to ensure that opposite party do not disturb the petitioner in any way until further order. Also further directed to provide necessary police protection, assistance to the petitioner whenever it intends to enter into the house of requirement. In any non-compliance of the order, OP, necessary legal action should be taken as per the law. So there is no prejudicial or harmful order that can be challenged before the writ court. Number one, the entire order has been given under the rubric of section 97 of the CRPC. So the petitioner, when the learned magistrate has held that the dispute between the parties are not adjudicatable under the Senior Citizen Act, matter ends. They could have challenged it if that particular direction, if they agreed of, they could have challenged it before the criminal revisional jurisdiction under 227 or 482 or 401 of this provision. So, but the writ petition, the writ is not maintainable only because then order of mere direction and innocuous direction has been passed against the petitioner, against the citizen. So where is the prejudice? I really fail to understand.
Done.
Yes, Lordship.
Mr. Sahu, right?
Yes.
Your name is Mr.
Arnab Shah.
Arnab Saha.
Yes.
Mr. Saha, tell me one thing.
Yes.
Once the tribunal has already concluded in the first order, which you read on page 56, I am of the view that the case related with the taking possession of dispute land and structure does not come under the purview of the Maintenance Act, so and so.
Yes.
Then how did he take up the matter again?
Again 97, can you see?
How could he pass these directions once he has
They-
already
No,
decided that the issue doesn't fall within the ambit of the Maintenance Act?
No, not Maintenance Act. Again, here it has been
On
stated that
page 60, how can he pass these directions?
section 97, Lordship, here.
Forget section 97, you go before the criminal court. We are only confined with the maintenance of Senior Citizen Act.
Yes.
All right?
Yes.
So don't put anything else in here. We are only talking about this. How did he pass this order on page 60?
Then I would
How
like,
did he open up the entire issue?
yes, Lordship. I would like to beseech your honor at page 58 of the.
I have seen
application.
page 58.
So here it has been stated that
Page 58 is a different section.
issue search warrant under
I've
section
seen that.
97.
I have seen that.
Lordship.
Once he has already concluded that he is not going to enter into this arena of dispute, which is civil in nature to the extent of a land and a property, how did he pass these directions after that?
So
Once he has concluded
when a magistrate,
that it is not maintainable, a petition is not maintainable, then how did he pass these directions?
when a learned magistrate, I'm answering to your
How did he
Lordship.
pass this direction? on
Yes,
page
Lordship, I'm answering your Lordship query. Lordship, when a magistrate, when sitting sit to adjudicate an issue, when the magistrate finds that the issue is there is something.
There is nothing, but all right, you file your reply.
Lordship,
Because he also doesn't seem to be the best person here. All right, take down.
Lordship, I will file my.
File it.
Yes. Lordship, I will file.
The petitioner has preferred the present date petition,
The report by the state.
challenging the order. What is the report of the magistrate?
Tarama is, my lord, here deal in SDO, my lord. So can it be put in the form of an affidavit?
Absolutely.
Fine.
File affidavit. The petitioner has preferred the present date petition, challenging the order dated 17/11/2025 and 22/12/2025, passed by the subdivisional officer and maintenance tribunal, Alipurduar, whereby the private respondent has been permitted
আমি আছি
to enter the subject premises as and when required, and the petitioner have been restrained from creating any obstruction, hindrance, or disturbance when the private respondent enters or resides in the said premises for his necessary use and needs. Learned counsel appearing for the petitioner assails the aforesaid order passed by the maintenance tribunal on the ground that the maintenance tribunal in its order dated 7/4/2025 had held that the case that the issue that the case is related with taking possession of a dispute land and structure thereof, which does not come under the purview and maintenance and welfare of Parents and Senior Citizens Act 2007. The tribunal had held that the parties the tribunal held that the parties shall approach the proper court of law for redressal of their grievances. He states that since the proceedings had already been concluded in the petition filed by the respondent, the impugn order itself is void and shall be set aside. Full stop. He further states that the tribunal was what is the other ground?
My lord, if they are deprived of this, my lord,
He
order,
further states that the tribunal itself should not have entertained the present petition. They should not have entertained the complaint of the respondent, since it was it was beyond the purview of the act. Full stop. Learned counsel for the respondent, Mr. Saha, states that the orders passed by the tribunal are within its jurisdiction. He seeks and is granted 4 weeks' time to file reply. Respond number, your respond number, Mr. Saha, your respond number,
I'm listening number 4.
respond number 4, Mr. Saha. And you are
state respondent.
the state respondents. Seeks and is granted 4 weeks' time to file affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter, list after 8 weeks before the
Grateful, lord.
available.
Grateful. Praying apology.
Why do you get agitated? Everybody seems to be.
ID number 2 is just now my land, we have some. I will got from my office. It's not circular.
Where did he go? We'll have it tomorrow. Did we pass it over?
Item number 2.
Pass over. Tomorrow.
12302. Item number 5.
Item number 5 on behalf of the petitioner. So on earlier occasion, there was a direction to serve a copy upon the private respondent number 4. So the copy was being served as per as the order, but the said copy was been refused by the respondent number 4.
The private respondent number 4.
So this is the copy of the affidavit of service. If the petitioner, the instant.
Who's respond number 4?
So it is the private respondents who has purchased the vehicle.
You are appearing for. Yes. Is there?
4,
I'm appearing for 4.
but it was been refused. Lordship, I have annexed the envelope.
All right, he's there now.
Lordship, if they have.
We have crossed that hurdle now. Come to the merit of the matter.
Lordship, the instant petition has been filed in respect of the inaction by the RTO authorities against the illegal transfer of the vehicle of the deceased husband of the petitioner. The husband of the petitioner was the owner of the vehicle, Lordship, but subsequently he died in the year 2022. But interestingly, his vehicle was been transferred after his death. Lordship, kindly come to the page number 13. It is the death certificate of the husband of the petitioner.
Page number?
13.
Yes.
The date of death is, Lordship, 12th February 2022. Now, Lordship, if
So there is a vehicle. Right?
which was been transferred after the
Who is
death.
the owner of the vehicle? You are the owner of the.
My husband was the owner of the
Your
vehicle.
husband was the owner of
Yes.
the vehicle. When was the vehicle purchased?
The Lordship, the vehicle was he was the owner of the vehicle, and after which, Lordship, the vehicle was been illegally transferred.
There is the ownership of the vehicle.
Lordship, kindly, Lordship, at page number 15, vehicle particulars.
Page number
15. Lordship.
So Sujit Burman is the husband, your husband.
No, no,
My- no.
The subsequent purchaser. Well,
He
I
is the
have purchased it from
subsequent
the
purchaser.
Husband of the.
Lordship, may I?
Yes.
Lordship, at page number 15, if you Lordship kindly see, this is the vehicle particulars which was been obtained by the plaintiff, petitioner. At the bottom, Lordship, it has been said the previous owner, Authorul Haq. Ship, fine.
Where is the bottom of the page?
Vehicles particulars, Lordship, at the bottom, previous owner, Atarul Haq.
Yes.
He is my husband. And Lordship, kindly see
There's
the,
permit area details.
Lordship, kindly see the date, transfer date, 6 December 2022. It was been transferred to the Sujit Burman,
Transfer date 16th December.
16 December. How come, Lordship? That is the one question, interestingly.
16th
And-
December 2022.
Two. Now, finding out that, Lordship, he find out that the petitioner find out that his brother-in-law has done it. He subsequently filed an FIR, and after investigation, Lordship, if your Lordship kindly see, the police has also filed an charge sheet, which has been page number at 18, page 18. From where charge sheet it has been revealed that the report which has been received by the police authority, it has been found that it was been fraudulently transferred in the name of the respondent number 4.
Where is that?
It is at page number 20, my lord. At page number 20, my lord, second paragraph. During the investigation, I, along with the force, my lord has arrived at 141 Changrabanda under PS Mitliganj, district Kujbiar, and visited the PO as shown by the complainant and local witness, and drawn a rough sketch map with PO with its index separate charge sheet. Thereafter, I examined the local witness recorded 161 statement and sent a notice to the complaint regarding the supporting documents, and later seized the supporting documents and the death certificate under proper seizure. I sent the photo and notice to the accused person, and later on complete the notice, but they surrendered before the London court. I sent the mail to the RTO. If you'll also kindly point it out. I sent a mail to the RTO Mathabanga regarding the vehicle which was been transferred, and I received the vehicle report of such and such from the RTO Mathabanga through Indian Post, and after perusing the report, it has been found that the accused has fraudulently transferred the ownership and sold the said vehicle to its new owner Sujit Burman, who is the instant respondent number 4. While the previous owner,
Who's the accused here?
Lordship, the accused was the brother-in-law. There was an allegation against the brother-in-law. His fraudulently has been transferred. The case has been initiated therein, but after finding out, the petitioner has wrote a representation thrice to the RTO stating that the vehicle has been illegally transferred, and it is to the knowledge of the RTO. But no action has been taken in respect of same. My lord, if my lord kindly come to page number 21 also, one RTI was been filed by the petitioner stating that how the ownership has been transferred, because he was at the time willing to transfer in her own name. But the information which he wants to derive, he asks the information, and the information was been provided to him to her by the authorities. Page number 21.
Yes.
It has been stated information sought for the RTI application dated and what are the required, this has been stated, my lord, at page 22, column 5. It has been required that procedure of RT transfer in favor of me, that is wife, and what documents are required. Lordship.
Yes.
What has happened in this case is that the previous owner of the vehicle, as it's evident from the RC, takes up page number 15 of the instant petition.
Yes, Mr. Rahman, I'm saying.
Registration, there's the vehicle particulars.
Yes.
Malad would find the name of the previous owner at the bottom part under the heading permit area detail.
Yes,
Previous owner's name is Atarul Bhav. The
Yes.
previous registration number is UP 70 GT 6543.
Yes.
So this vehicle was initially registered in the state of Uttar Pradesh.
Yes.
Subsequently, it was transferred to the state of West Bengal, and the WB number, my lord would find in the top right hand corner.
Yes.
Registration number is now WB 85 3697.
Yes.
So in this vehicle was transferred from a UP registration to a West Bengal registration. Now, as regards the transfer when it was made, my lord would find the entry date below the UP registration number. My lord would find the entry date 4th October 2021.
Yes.
So this was the date when the application was made by the husband of the present petitioner who was still then alive. The application was made during his lifetime. I received this particular registration certificate. This transfer date was mentioned there in the 16 December 2022. I received it after his death, but the application was made by him when he was present, when he was well and alive, and that application that is reflected in the entry date, that is 4th October 2021. Not only that, Malad would find the permit also. The permit needs to be changed since it is transferred from one state to another. Malad would find the permit date in the permit area detail just above that. Permit valid from 29th November 2021.
Yes.
So my application for permit was also previous to the date of death of the husband of the present petitioner. And also, my lord would find, when did I deposit the fee, my lord? The below the detail permit area, below the heading permit area detail, fresh permit fee, weighted receipt number such and such WB 85 SR dated 29th November 2021. So I deposited on November 2021 when the husband of the petitioner was alive. So this vehicle was lawfully transferred into my name. The certificate, this registration certificate was issued. The transfer date was written there in the
Not at
16th
all,
December,
Mr.
which is
Rahman.
subsequent date.
This is entry date doesn't mean this might just be the entry in the portal.
Yes,
That
yes,
doesn't mean the
yes.
transfer
Procedure
has-
is he has to appear before the authority concerned, RTO.
So
He
how,
has to.
when did he appear before the RTO?
Well, that is the date that is stated therein. That is in 2021.
So 4th October 21 is not the entry date. This is the entry in the portal.
Yes,
When did the
after he
transfer take
appears
place?
before the authority, only then it is
That-
entered into the
That
portal.
document is not available.
The transfer,
Because-
when did the transfer take place? That's on 16th of December
No, no,
2022.
this is the
How
date
can the
which-
transfer take place after his death?
No,
He
no,
died in
this is-
February.
No, he died in February.
Yes.
But the transfer, this is the date given by the authority concerned.
What
I
about,
received it
what about
after.
the police finding?
Well, the police finding, what does it state? Mala takes up the
See
finding of the
that?
police. Mala takes up the, once the report that has been filed by the police.
Accused had fraudulently transferred the ownership and sold the said
Well,
trust
there
to
is
the new
nothing,
owner.
there is nothing regarding that the brother of the so-called deceased husband.
This is the finding
Well,
of the investigating officer.
well, that finding, I am not even an accused in that. I am not
You are
even
not
an
an
accused in
accused. The
same
person who has sold the property is the accused.
Well,
but the
he
vehicle-
could not have sold because he is not the owner. It is the husband who is the owner.
The allegation is that it has been fraudulently sold, and
Yes.
this is what the conclusion is after the investigation has been done.
Well, the brother of
Whatever
the,
it is, you decide. Why have you not decided the representation of this?
That can be done, but we are not concerned with the sale because the sale takes place between the transfer vendor and vendi.
If the
After-
person has
after-
died, if the person has
No.
died, how did the sale take place?
That cannot be.
All these people come to the RTO.
No, after purchasing the vehicle, the law is that as per section 50, they will apply online before the concerned registering or authority for transferring the name in their our part. So far the RTO is concerned, his role is only to register the name and change the name of in place in the RC in the name of the present owner. We are not concerned with the transaction. Transaction takes place between the seller and the purchaser. After
You are saying that you have.
he has,
purchased the property.
he is the purchaser.
You have purchased the
He
vehicle.
has
purchased the
purchased.
How did you purchase it?
but it was sold to me by the husband of the.
How did you purchase? In what form? Where's the cash? Where's the check?
But that I have to take instructions for.
You take instruction.
Yes. definitely.
It doesn't look like you're purchasing.
No, I purchased the vehicle. I have the details.
Take instruction. You come back. And in the meantime, you have to decide the representation. Why you're not deciding the representation?
Because they were asked, they did not produce because the registration authority has asked the dispute is between the, not between the owner.
Whatever, then
They are,
you will decide the representation.
Lordship, that can be done. If we are director, we will dispose of this representation.
You have to decide the representation of the person.
They were asked, they did not appear. That is the problem.
You come back, Mr. Rahman, with the
I'll come back.
instruction.
I'll come back with the papers, the ownership papers. also.
Yes. When do you want Tuesday? Tuesday. Tuesday.
Tuesday.
Lordship, may I have one indulgence, let the state also be produce some reports, how come they registered?
How
the-
we can produce the sale?
Nothing, no report right now.
তখন দেখুন।
I'll come back in 5 minutes.
Item number 6.
Well, it's the similar, my lord, absolutely identical matter. Your lordship had passed two orders yesterday.
Show cause notice?
Yes, my lord, the cancellation of my lord registration on the ground of non-filing of returns.
तीन बছর delay.
You will pay the tax.
Yes, yes, yes.
Penalty.
Yes, my lord,
You have already got the order.
penalty fees, whatever my lord will pay.
Just give me the order date. Cancellation.
Show cause is dated,
First cancellation. Give me cancellation.
the order of cancellation is my lord, 3rd of February 2022, page 21.
3rd of February,
Yes, my lord.
2020.
So 2022.
Out of February 2020.
Not from retrospective, from the same date, right?
From the same date.
All right. Mr.
I'm sorry, my lord, the effective date of cancellation is 1st of July 2020. That is retrospective effect.
1st of July.
1st of July 2020.
That's why I asked you. ये reason नहीं है?
Order was passed on.
Effect, completely.
Yes. Your name is Mr.
Ghosh, Vikramaditya Ghosh.
Paying the penalties, the pains will be. Yes, as per the order, they will.
They have to.
They have. Is what, because there is a judgment regarding this.
You were granted the registration on
28th June 2017.
show cause on
My lord, the show cause was on my lord, 26th November 2021.
Order was passed on 3/2/2020.
when did you get to know of the cancellation?
My lord, we did not provide any specific date. My lord, it was on during February 2026.
Or we'll remove this. That paragraph number 3 will be removed.
Yes, my lord.
Learned counsel respondent submit the petition of the preferred asylum is not the petition and submit the petition.
Remaining will be my lord,
Remaining same.
same.
All right.
Yes, my lord.
Miss
Mine.
Rima, the same order.
Mine.
Yeah. Same. Yeah. Date. This one. Yeah.
Grateful.
Party नाम है पार्टी नाम था वो चेंज पूरा देंगे.
Item number 7.
Item 7, my lord, I beg to appear on behalf of the petitioners.
Yes.
My lord, the brief fact of the case is that I am the owner of the land and resident mentioned in the cost title, and the private respondent is my neighbor, the adjacent land to my property. And my lord, the grievance is that, my lord, the private respondent has made his construction without violating the panchayat rules, my lord. The West Bengal Panchayat, Gram Panchayat Administration Rule 2004, Section 24, subsection 1, where it is clearly mentioned that there must be a minimum setback of 0.9 meters.
Rule section.
Section 20,
24.
Rule 24, Rule 24, 1. Yeah, my lord. Why it is clearly mentioned that there must be a minimum setback of 0.9 meters, that is 3 feet from the boundary line. My lord, my only humble submission is that there must kindly direct the Pradhan to submit a report that whether there is any violation of the rule or not. Despite of several representations, my lord, I have made several representations before the authority, Pradhan, Panchayat, and BDO and all.
Who's appearing for the Pradhan?
No, you are not Pradhan. Pradhan is served in the affidavit of survey.
We are not, we are waiting for the state.
State respondent is BDO, my lord. I have made
Decide who will decide his representation.
Pradhan,
Pradhan.
so far construction is concerned.
I'll pass a direction to the Pradhan. He's not here.
Yes.
You have served him, right?
Yes, I have served the affidavit of service is there. my
To
lord.
the Pradhan.
Great, my lord.
Will decide.
Goriati, respond number 6.
Data. The petitioner preferred the presented petition being aggrieved by the alleged inaction on part of the respondent authorities in not taking any steps against the purported unauthorized and illegal construction carried out by the private respondent at Moza, Guriahati, LR plot number 5162, jail number 126, LR Khatian number 4211. Right?
Yes, my lord.
Full stop. Learned counsel, Mr.
Shubham Chanda.
Shubham Chanda, appearing for the petitioner, submits that the private respondents alleges that the private respondents has encroached upon the petitioner's aforesaid land and has carried out construction, unauthorized construction, illegal and unauthorized construction in the form of a double-storied building without obtaining any sanctioned building plan and without maintaining the requisite setback in terms of the Gram Panchayat rule 24-1, right?
24-1, my lord. Yes, ma'am.
Gram Panchayat rule.
Yes, ma'am.
West
West
Bengal,
Bengal.
West Bengal Gram Panchayat Rule 2004, Lordship, Rule
West
24.
Bengal Gram
24-1.
Panchayat rule 2004, particularly rule 24-1.
24-1.
It is further submitted, learned counsel for the petitioner further submits that he has lodged several complaints before the Pradhan dated 25/5/2025, 16/9/2025 and 17/2/2026. No, ऐसे कर देना. He has lodged a complaint before the Pradhan dated 22/5/2025 and thereafter before the BDO on 16/9/2025 and 17/2/2026. BDO में कर देना, Block Development Officer. Full stop. However, no steps have been taken by the authorities till date. Full stop. Being aggrieved by such inaction, the petitioner has preferred the present petition. Full stop. Who will take action? Pradhan will take action.
Pradhan.
Having heard the counsel for the petition that upon perusal of the materials placed on record, this court finds that the grievance of the petitioner is primarily with regard to non-consideration of his complaint/representation submitted before the competent authorities. Full stop. This court is not inclined to adjudicate the disputed question of facts involved in the present matter, particularly with regard to allegation of encroachment and unauthorized construction. Full stop. However, considering the facts that the representation of the petitioner remain unattended, this court deems it appropriate to direct the competent authority to consider the same in accordance with law. Full stop. Accordingly, respondent number 6 is directed to consider and dispose of the petitioner's representation dated 22/5/2025 by passing a reasoned order strictly in accordance with law after affording an opportunity of person hearing to the petitioner as well as the private respondent or any other stakeholder. Full stop. The said authority shall also cause an inspection of the site in question if deemed necessary and take appropriate steps in accordance with law, including with regard to any unauthorized construction if found on the said property. Full stop. The entire exercise shall be completed within a period of 8 weeks from the date of communication of this order. Full stop. It is made clear that this court has not expressed any opinion on the merits of the case and all issues are left open to be decided by the competent authority in accordance with law. Full stop. With the aforesaid direction, the present petition stands disposed of. First line, लिख लेना, affidavit of service file. None appears for the respondent number 6. Hit करना.
Deeply obliged.
Deeply honest.
Right service none appears for respondents.
Great, good.
Item number 8.
Yes.
Milord, I am for the primary board.
Yes.
Milord, 8 to 15, Milord, are similar matters. On the last occasion, Milord,
You
I-
sought time.
I sought time, Milord, to inquire whether any appeal has been preferred against, Milord, the orders upon which the petitioners are relying upon.
Yes.
Milord, there are several appeals that has been filed by the primary board. Milord, one, Milord, I could get the case status, Milord. This is MAT 920 of 2025.
Yes. What
And
is
Milord,
the-
there are several other appeals also which are pending.
Filing of appeal doesn't mean that order.
No, I am
can't
not
be
saying that,
passed.
Milord. I am just
What is the
intimating.
status in that appeal? Any
Milord,
stay?
it has not been heard. Milord, it came up before the honorable division
File
bench.
appeal in this also.
Milord, I have no problem, Milord. It's my
Mr.
duty
Ghosh,
to.
what? If any order would have been passed by the division bench, I could have understood.
Yes, Milord.
But if
No
no-
order has been passed, there is no stay.
Then
Page 39.
page,
Page 39, madam.
I am applying for the respondent number 6, under the DPSC which we had.
yes, Ms. Bowal,
Milord would be, Milord,
the petitioner has challenged the inaction of the district primary school. What is which one is this? In item 8.
Item 8.
Just give the details. Why don't you just give the?
Malad, kindly then fix it tomorrow. I will come with the corrected order and
Just
give it
give
a
the correct order, finish it or no, give it right now.
Malad,
Give it after.
at 2 p.m. Malad.
Milord, kindly records my submission that, Milord, I have, there's an appeal has been filed, but no stay or whatever, Milord records. At least that is my instruction, Milord.
Give the,
At 2 p.m. Malad, I will come with the
give the
corrected
details,
order.
otherwise.
I will come with the
8 to
correct.
15, you give the details at 2 p.m.
Okay.
We'll take it at 2 p.m.
Great.
Give the details.
Great.
To 15. Item number 16.
I am with respondent number 4, my lord.
Rules for the petitioner, sir. Not today. Tuesday. Who's there, Miss?
Number 16.
Rima? Nobody is here for the petitioner. Who's for the petitioner? See them?
The last occasion, the day before yesterday, my lord, has taken up this matter. And I appeared online, my lord. And he was submitting that because of the reason, my lord, they have challenged the adjudication order after 2 years. The order has been passed in 2023. The recovery proceeding has been initiated by the State Department. My lord, they are asking for basically, my lord, asking for the amount from WBACDCL. They, after 2 years, they are challenging the adjudication order before your lordship.
Nobody is here today. Tuesday it is.
As your lordship pleases.
They can prefer an appeal,
He has not preferred any appeal.
No,
but condemnation. Generally, the,
Yes, that is an issue, my lord. As because he did not file any appeal.
so what is the law on that?
3 months plus 1 month, 4 months, within which he has to file the appeal. My lord.
This court has been passing orders condoning the delay.
Yes, it does.
You have some orders? You have some
And
orders?
there is a judgment of the division in SK Chakraborty, and subsequently the many order has been passed by this honorable
Where
court.
the delay has been.
Yes, my lord. My only thing is that, my lord,
You are
there
there?
must be
Mr.
sufficient
Mishra,
cause.
You are there? Item 16.
Malad, sir,
No, there must be sufficient
Where's the
cause in
brief?
preferring appeal.
Malad, can
The
you pass it
junior
over?
has it.
Pass it over from. I am incapacitated. My junior is not here. All right. Just another after the next matter.
Pass over.
Wait.
Item number 17.
Seventeen.
17, my lord, I appear on behalf of the private respondents.
Private respondent. Is a gratuity matter. What are you doing? 17.
I bow down, my lord. I have 18.
Pass over. No, this is passed over. Let me just take you.
Item number 18.
18 for the.
For short passover. In this matter, Mr. Kunaljit Bhattacharya appear in this matter, Your Lordship.
Pass over.
Granted, Your Lordship.
Item number 19.
19, my lord, service not completed, my lord. Praying for kindly fix them around 25th, my lord.
25th is what?
Pencil status.
25th.
Grateful, my lord.
Okay. Oh. 19 এ তুমি নেই 18
Item number 20.
My lord, item number 20, to apply for the petition. The lordship can do it. Now, this matter relates to, my lord, the transfer of an assistant teacher teaching in a primary school, my lord. Last occasion, my lord, yesterday, my lord, learned advocate for
Can't hear you. Can't hear you. Not audible. Tell your senior is not audible. Can't hear. Send a message. Send a message to him. He is not audible. Also, you're there in this matter. Who's there?
Lordship, I'm for the DPSC.
We'll pass it over.
Similar.
Alert.
Representation consideration.
Item number 21.
Call madam.
Hey, what they want is the representation to be considered.
Who will consider?
my lord.
Me, Lordship, chairman DPSC. There's a simple person over there. Take it now.
20.
Louis.
Petitioner has preferred the present writ petition, alleging inaction on part of the respondent. Authorities are not considering the petitioner's application dated 1/9/2025 for transfer from Thupguri Circle to Jalpaiguri Sadar East Circle. Full stop. Learned counsel for the petitioner submits that the petitioner was confirmed as an assistant teacher with effect from 5/8/2012 from Jalpaiguri Senior Secondary Primary School. Full stop. From the Jalpaiguri Senior Secondary Primary School. On 5/8/2017, she had been transferred to Jalpaiguri Government Girls Primary School of Sadar East Circle. Full stop. She is working in the school temporarily. However, for taking salary, she needs to travel to the mother school situated at Thupguri Circle.
Because the transfer was temporarily.
Since the transfer was temporary in nature. Full stop. She claims that due to her illness, it is not possible for her to travel to Thupguri Circle. Full stop. She states counsel for the petition states that she had originally made an application on 12/12/2019 for transfer, full stop. Finding no reply, he filed another application dated 18/8/2024, followed by another application dated 1/9/2025. Full stop. The said applications are pending before the, who applications are pending before?
Lordship,
Respondent number two.
18/4/2025, Lordship.
No, pending report.
Have been pending before the chairman,
Chairman.
have been forwarded to the inspector of Dhupguri to the chairman, district primary school,
18/8.
by the sub-inspector of, school inspector of Dhupguri to the chairman, district primary school council, Jalpaiguri, and the same is still pending. Learned counsel appearing for the respondent number
2, Lordship.
2 submits that the competent authority has no objection if the representation submitted by the petitioner is considered and decided in accordance with law.
According
Full stop. Learned counsel for the petitioner submits that he would be satisfied if the said representation is considered and decided within a time-bound manner. Having considered the submissions advanced by the counsel for the parties and without entering into the merit of the claim of the petitioner, the present writ petition is disposed of by directing the respondent number 2 to consider the petitioner's representations in accordance with law.
Date created.
In accordance with law and the relevant rules by passing a reasoned and speaking order within a period of how much time, sir?
Lordship, now the elections are coming, so
8 weeks?
8 weeks.
Within a period of 8 weeks from the date of communication of this order.
Shall we do best?
It is made clear that this court has not expressed any opinion on the merit of the petitioner's claim, and all issues are left open to the competent authority to be decided in accordance with law. With the aforesaid direction, the present petition stands disposed of. Item, the next is also there. The next, there is one more item, right? 2021,
21 is.
only 20.
Item number 21.
Lordship, in item
I
number
am for the
21, the
petition.
returnable date is 20/3/2026. Yesterday, Lordship, Lanet Additional Advocate General addressing this court.
24th,
Lordship, kindly fix it on Monday, Lordship. By this time, report also come.
Tuesday,
Tuesday, Lordship,
Tuesday.
Please.
grateful.
Which matter, Mr. Mazumdar, which matter?
Item number 22.
Lordship, I really got the respondent, Lordship. Yesterday late night, the read, so I put the accommodation for Monday.
Mr. Agarwal, I can't hear you. Mr. Agarwal.
Lordship.
Yes, Mr. Sen, I can see you're appearing for the petitioner. Let me hear Mr. Agarwal, what he wants to say. He wants a date or something?
Yes, Lordship. Monday, Lordship, because yesterday only I received the read, Lordship.
All right, that's why I asked. Tuesday, Mr. Agarwal, be here.
My lord, with your permission, if I may place on record the affidavit of service.
Tuesday. Place whatever you have on Tuesday. Not today, Tuesday. Tuesday, Mr. Sen. And Mr. Sen, your connection is not good at all. So if the same situation is there on Tuesday also, you better come here.
Item number 23.
Lordship, for item number 23 as well, I'm praying to be fixed on Tuesday.
Why?
Lordship, I have instructions from my senior that from item number 25, since the learned seniors have come from Calcutta, 23 will take some time. So if your Lordship may fix it on Tuesday.
Nothing takes time in this court.
Lordship, kindly fix it on Tuesday. Great, Lordship.
Wednesday.
Wednesday.
Witness.
Item number 24.
24, Millard, your lordship was considering a similar matter, Millard. This is Millard regarding Millard
16.5.
applicability of 16.5. Now, Millard, what has happened here, Millard? Millard, initially, Millard, the proceedings started with the scrutiny proceedings, where Millard, it was found that Millard, I am obligated to Millard return ITC which was found reversible. Millard would take the scrutiny report ASMP 10 at 21, page 21. And Millard would just take note of the scrutiny period, that is Millard, the financial year, assessment year 18-19.
18-19, yes.
Yes, Millard would just take note column 3, ITC availed in excess, column 4, ITC found reversible, column 5, interest payable. Now, Millard, so far as 3 and 5 are concerned, Millard, that is admitted, we have reversed it with interest. There is no dispute. 4, Millard, we have disputed and has not been paid. Eventually, Millard, proceedings were initiated. Millard can straight away skip over to page 33. Which is Millard, the adjudication order, DRC 07, in form DRC 07.
Yes.
Again, Millard could find at column 4, Millard, ITC found reversible if availed. Now, Millard, in my case, this ITC which was found irreversible, Millard, was availed during the year 18 and 19. And Millard would find, I'll just show Millard, Millard can, if comes back at Millard, the scrutiny proceedings, so the scrutiny ASMP 10, the annexures to the ASMP 10 at page 25. Column 4, capital A, page 25. Four capital F. ITC availed in GST at 3 capital B filed after the last date prescribed under section 16.4. From table 4A of those GST at 3B that have been filed after 2010-2019. This was, Millard, originally what 16.4 was. Subsequently, Millard, when 16.5 came in with retrospective effect from 1st July 2017, this, Millard, is an incorrect observation in view of the provision which was, Millard, incorporated by way of 16.5. So, Millard, I am only claiming benefit of this, that in view of section 16.5, that the extended period was there. We filed our returns before the extended period. Let them reconsider the decision. Adjudicating authority.
Well, the adjudication order is in page 33, which was passed on 14/3/2024.
Millard, before Ms. Shortcut starts, Millard, our coordinate bench, Millard, has already decided this. Millard, I'm just relying upon one decision. Millard would just take note of this.
No, that is not the correct observation.
I mean, page 36, Millard, is the clarificatory circular issued by the Department of Revenue at page 36, Millard, where the department now have, Millard, clarified what is the effect of this retrospective operation of 16.5. डेट तो डालना चाहिए था। चीजों ने डाल दूं। ASMT का? ASMT नहीं, this actually filing कर रहे हैं. That is the most important. It's on the file.
Yes,
May I, madam?
yes.
The adjudication order was passed on 14th March 2024. Why this notification, madam? Please, sir. Bulch. Notification 22 of 2024, you have written in your application, which came in 8/10/2024.
Adjudication order passed on 14th March.
My lord. 2024, and thereafter this notification of 16/5 came in, my lord. And where it is clearly specified that the said person shall file electronically on the common portal within a period of 6 months from the date of issuance of this notification and application for rectification of an order issued under section 73, 74. So this 6 months period has already elapsed. He did not file a rectification.
Where are you reading?
Para number 2, my lord. Notification. In order to get the benefit, my lord, he has to file a rectification of the order. He didn't file within this period of span of 6 months.
Yes.
So, my lord, now he is coming before your lordship to condone that period, ma'am.
Any judgment where it has been condoned, sir?
But I have to find Millard, but here what
Because
the
No, it
The
is there is
judgment
no-
notification is very clear.
Millard kindly takes Millard subsequent to the notification, they have issued a clarification. Kindly takes page 36.
Yes, even in the clarification it is given.
36, Millard would start Millard from paragraph 3. The following action may be taken by the tax authorities and or the taxpayers in various scenarios for availment of benefit on account of retrospectively inserted provisions of subsection 5 or subsection 6 of section 16. Now, I am covered Millard under section 3, capital 3.5.
5.
Where the order under section 73 or section 74 of the CGST Act has been issued, but no appeal against the said order has been filed with the appellate authority, or where the order under section 107 or
No,
108
but then
of-
still you can't overcome this.
No, this 3.5 says the same thing, that I have to file a rectification application
Within 6 months.
within 6 months.
Yes.
Even my prayer in the writ petition is also that your lordship would kindly permit me to file the application for rectification. Now, my lord, I am only on 2 points. Lord, an adjudicating authority passing an order in 2023 is not aware of a provision of law which is there, because this notification did not bring in the amendment. This amendment, section 16.
This notification has come subsequently, but it has given you a window of 6 months.
That is not my procedure, what procedure I would follow. But the substantive provision that the period of filing Millard for the GSTR 3B is extended up to a certain period. That extended provision, that 16.5 speaks of, that was incorporated long back. So an adjudicating officer in ignorance of law passes an order. Then I had to land up in these trappings of procedure. That is Millard, the unfortunate part. Now, Millard, I am only praying 2 things, Millard. Either Millard condones the delay and allow me to file a rectification in terms of the clarification.
When did the 16.5 come into effect?
Millard, the 16.5 was Millard. It was notified under Millard in the
16.
Finance Act 2024 with
In-
retrospective effect.
On 16/8/2024 with effect from 27/9/2024. I have the new parent. If your lordship wants to see.
So the order has been passed on 14th of March.
14th of March.
Subsequently, the
Subsequent-
amendment has come in.
Subsequently,
It
the
has given a retrospective effect, but then you should have availed your remedies within 6 months.
I have missed that. There's
have
no
missed
doubt
that,
about
then
it, I have missed that.
Anybody who has slept over his right is not entitled to get the benefit.
No, my lord, since your lordships are condoning the delay under section 107 also.
Yes,
under
that's
the
a different
GST
thing
Act,
altogether.
my lord, now this is some benefit which the act has, my lord, the statute has granted upon you,
To only people who are
who
aware
has,
of,
my lord, exercised their right.
yes.
Now, my lord, I have somehow missed that. And I have stated in my petition also, my lord, that this is something the
What are
person,
the grounds of delay?
my lord, kindly takes, my lord, I'll just show your lordship my pleadings.
Yes.
My lord, paragraph 12. This clarificatory circular and notification, my lord, both missed our notice, the person who was handling my accounts.
That's all, that's your problem.
That may be, but my lord, kindly takes a considerate view that this is an entitlement granted by the statute. And merely because someone has missed it inadvertently, my lord, he should not be deprived of this. The other amounts which they have claimed, I have already paid. This is the only amount, my lord, which is now remaining. And, my lord, I am entitled to this by way of, my lord, the retrospective application of law. And, my lord, I have missed that procedure which was prescribed.
Not inclined.
So in that event, my lord, kindly allow me a day's time. My lord, I'll just find out in similar circumstances where our court has
Come back. Tuesday.
grateful. my lord.
Great.
এটা যা দীপ্তদা ঢুকছে লাইনে হ্যাঁ ঢুকছে
Item number 25.
Mr. Mazumdar, what happened?
Lordship's
Who's, yes.
Lordship, this online, the copy not served your Lordship till we need to instructions from the department after receiving the copy. That's the problem.
Serve a copy.
25, 6, 7, 8.
Subject to whatever the learned solicitor submit. And this is the matter in notice under section 1 of the income tax law issue, has been issued. Treating me as an assessee in default on account of alleged failure to deduct tax at source. This is for the financial year 2021, and there are 3 or 4 equations covering different financial years. Now for the fiscal 22-23, identical order disposing of my preliminary objection as to assumption of jurisdiction to reject. I came before this honorable court by a requisition, and that requisition has been entertained because there is no appellate provision regarding other disposal of an preliminary objection. And my lord, order has been passed by the coordinate bench that the proceedings may continue, but no final order should be passed without leave of the court. In fact, the order impugned, all these orders impugned, these are identical orders if and when compared to the order which was challenged in the petition which has already been entertained. In the impugned order, they also refer to that financial year, being financial year 22-23. All I am seeking is that, my lord, they were supposed to file affidavit. Till date, my lord, I have not been favored with a copy of the affidavit in opposition in the earlier petition. Though different financial years are involved, issue is identical. So obviously, my lord, everything has to be decided in the compendium mode. So all I see, my lord, a similar order as passed by a coordinate bench, the lordship will find that.
ঠিক আছে না
And it was also the impugned order is at page 99 of the petition, which is again, my lord, is identical to the order impugned in that petition. I brought that order.
Yes, Mr. Majumdar.
My lord, if the copy could have been served on us well ahead, we could have come back with ready with instructions, my lord.
Yes,
We received the copy
Alright.
yesterday only.
yes.
My lord, kindly allow us
Yes, yes,
to
yes.
Tuesday.
When do you want? Tuesday.
My-
All right.
Instead of Tuesday, next Friday.
My lord,
Next
next Friday, Mr. Majumdar kindly consents if my 27th I will not be available, my lord. Please.
Tuesday we will come, my lord.
I should not be
Tuesday.
dictating Mr. Majumdar and there is no.
No. But there cannot be Majumdar versus Majumdar.
Yes.
But it is always Majumdar versus Majumdar, my lord. One Majumdar asserts and another Majumdar refutes.
That famous Hollywood movie Kramer versus Kramer.
Kramer versus. That was a good movie.
It was a good movie. Dustin Hoffman, Meryl Streep.
I learned
A
how to
wonderful
make
movie, sir. Wonderful movie.
French
Wonderful
toast from
movie.
that. If you remember,
wonderful
he make
movie.
French toast for
And my lord,
Wonderful.
just see the similarity. Both the Majumdars have seen Kramer versus Kramer.
And the honorable court too.
I think it was Dustin Hoffman.
Dustin Hoffman, Meryl Streep.
Meryl Streep.
Meryl Streep, Justice
Four
Hoffman.
is similar. 25, 6, 7, 8.
All on.
Well, I will expect now that I am not seeking any order from your lordship. I will expect that since your lordship is hearing the matter, I hope they will not take any steps in the meantime. I hope that's all I say. So we come
Mr.
back on
Majumdar,
Tuesday.
Mr. Majumdar, please consider
There's some order
SIR
passed
is
by
on our head.
there is some order passed by the Supreme Court also, right?
Yes.
No, my lord,
Right.
SIR is
So-
sitting on our head. Most of the officers
So
have
the,
been
what the
drawn out.
Supreme Court says, that you can carry on with the, which is similar
Which is
to,
what I'm seeking.
which is similar to this,
Yes, similar.
but you will not pass any orders
That is all I'm seeking.
subject to the, consent of the Supreme Court.
Right. That is
My
all
lord,
I'm
my lord, I need to just get confirmed by the department. Mr. Majumdar would understand my
naturally.
position.
No, that's all right.
say that.
And that's why I'm not pushing you, Mr.
My
Majumdar.
lord, my lord.
We'll have it on.
Oblige, my lord, oblige.
But that's what it says, that, subject to the proceedings
madam.
can go on, but no final.
That is
Yes,
all
my
I say.
lord.
Straight. We come back on Tuesday.
Grateful, my lord.
Item number 29.
Mr. Majumdar, the only thing which I find here is, in that
Lordship.
order, it says leave of this court.
Service
It should actually be the leave of the Supreme Court, not this.
বলুন না সামনের সপ্তাহে করুন
Whether the entire file could be transferred to please.
That's right. So that is pending.
Yes, that is pending.
But since the subsequent proceedings have also arisen,
This is 201 proceeding.
that's right.
Yes,
That's right. But since the transfer proceedings are pending over there,
yes.
because the transfer has taken from Madras to Calcutta,
Right.
right?
Right.
So that is the entire issue
Right.
that you are, which is being challenged in the Supreme Court, that it should not have been transferred. So since that issue is pending, but at the same time, Supreme Court had said that it should not, the proceedings can go on,
Yes.
but the final outcome would be subject to the approval of the
As
Supreme
an
Court.
officer of the court, I must tell you, Lordship, there are 3 TANs. One TAN is in Coimbatore, which actually deals with this lottery business. The TAN in Bengal, that is here, I mean Jalpaiguri or Kajiri, that Shiliguri, that is with regard to the hotel business. There is a third TAN. So, whether it is the case of the department, whatever happens in the Supreme Court, we are not bothered. Since you have a TAN here, we will just carry on with the 201 proceedings.
Yeah, the proceedings have not been stayed by the Supreme Court, but
That is what I'm saying.
but then I'm saying that subject to the approval of the Supreme Court, the final order can be passed.
That.
Not subject to approval of this court. That is the only distinction which I.
Because the lease is not before the Supreme Court. This list is not before the Supreme Court, subject to your lordship's.
That you have to confess.
Absolutely, this list is not before the Congress. Because this is a 127.
That's the only thing which came to my mind. So I
Right,
thought,
right.
Item number 29.
No, we are for the state. The copy of the application has not been served upon us.
Actually, what happened, we are not able to find the track because it misplaced the postal line.
Yes.
Let there be a direction for fresh submission.
No, you have to serve on the state also.
Yes, yes, sir.
you do it. We'll keep it on Wednesday.
Malan.
Item number 30.
Well, item from item number 37.
Yes.
These copies has not been served upon the GP office. Very unfortunate.
Do it. When do you want? And then take instruction also.
We have no copy. They have not served.
You understand the issue is gratuity.
That's all.
Yes.
But until we get the copies, issues are different.
Copies. We'll have it on Tuesday.
That is-
You give the copy today only so that he can come with the
Yes,
instruction.
yes, yes.
Wednesday, we'll keep it on Wednesday.
My lord, my lord.
And in the meantime, please take instruction. Any matter? The password? The password. Which password? Good. Which matter item?
Item number 16.
Item number 16.
Very quickly, with my lordship permission, I may recapitulate what I was saying when the matter was last taken up. If I can
Only
have
one
your-
Passover or there are more Passover? Hey,
16, 17. There are two more.
16, 17.
If I can have my lordship for a moment.
2 p.m. you'll see at 2 p.m. Passovers are, how many Passovers are there? 2 p.m. Yes, Mr. Vishnu.
If I can have my lordship for a moment, once again on page 23.
My lord will be taking up the rest of the Passover matters at 2 p.m.
No, we'll just, I don't know how much time will it take. How much time?
2 p.m.
Till 2?
2 p.m.
They should come at 2 p.m.
No, they should come at 2 p.m.
No, they'll come at 2 p.m. This will take some time.
Usually Mr. Vishwa's case is taken.
No. That is a very wrong impression that has been created. There is nothing like that. If I can have my lordship for a moment on page 23. My lordship is aware that the GST Act came in 2017. In June 2017, in the middle of a financial year, it was abruptly brought up. My registration certificate at page 23, this is my lordship, happens to be my permanent registration certificate. It was the date of issue of the certificate, my lordship will find is second column from the bottom, it's 31st of January 2029. Before that, I was working under a temporary certificate or a temporary registration. At page 26, my lords will see that when I was working under the temporary
This registration certificate on page 23 is
23 is the permanent certificate.
2019.
2019, yes. The date of issue is 31st of January 2019. Before that, what used to happen was I was referring my lordship for a moment on page 26.
Oh, yes. This
So
came before.
initially, what used to happen was I was working with what is called a provisional GSTI number. So in the sixth column, my lords will see for the financial year 2017-18, I made a voluntary payment. It is voluntary would be apparent from column number 3. I made a voluntary payment of my lords 5 lakh rupees. And in column number 8, it says that the voluntary part payment of GST payable in respect of provisional GSTIN such and such. So I was working under a provisional GSTIN, and the period was from 7/17 to 3/2018. And then there are other payments also that has been done. Another payment we'll also find is at page 29. Again, a voluntary payment. Clause 3, I'm so sorry, Lords, table 3. Financial year 17-18.
One was 5 lakhs, one was 2 lakhs.
One was 5 lakh, one was 2 lakh. The tenure is from July 2017 to March 2018. It was in June 2017 that the act came into place. Then, my lordship, there are other payments also that I have shown. What I am aggrieved of, first, my lords, is usually, my lords, I would have taken my lordship to the order impugned and then to the consequential order, but for my convenience, my lords, we kindly have page 39 first.
Yes.
The GST authorities were of the opinion, my lords, that a sum of 29,33,518 on account of tax, cess, interest, penalty is payable by me, and therefore they have written a letter to the manager of the Axis Bank, which happens to be my bank, for freezing of the account and garnishment process. The second letter that I am is aggrieved of is at page 42. This is also a consequential order. Page 4 to 42. Because I am a government contractor, I work only for a department called WBSC DCL. So at page 42, what they do is, the revenue authorities, they send a letter to the manager, finance and account, West Bengal WBSC DCL, intimating them that 29,33,518 is due and payable, and therefore if any payment is there, that has to be directly paid to the revenue department. All this arises out of the order impugned. Now let me have my lordship for a moment on page 59, which happens to be the order impugned. And lords, this needs to be very meticulously and minutely looked into. The date of order, my lords will find, is 12/12/2023.
Date of order 12/12/23.
Yes, it is an order under section 73(9). So not a fraud case. It is not an order under section 74. It is an order under section 73(9). First paragraph. As per records available, there appears apparent mismatch in turnover declared in GSTR 1 and payment received as per 26 AS of IT Act and TDS deducted thereon against the RTP span. The table below shows the summary of discrepancy noticed and intimated to the RTP by post. So at the first occasion, they intimate by post, which I do not think they will be able to show, but still, the issue is something larger. Intimated to the RTP by post and mail for the aforesaid period. What is the period? The period is 2017-18. There is an outward supply that is shown, and then there is a difference also that is shown. So what they are trying to say is that when my IT, because everything is on the portal, everything is available with them. So when they were going through my IT returns, they found that there is certain discrepancy between the TDS that was deposited or the tax amount that was deducted on account of payment made to me vis-a-vis the GSTN entry that I have made into the portal. That's their grievances. In 2017-18, because what happened was that the GST came into place in the middle of a year, in the middle of a financial year. The financial year starts from April. It was introduced in June. There cannot be a single return unless somebody has not worked at all. There cannot be a single return in 2016, 17, and 18, wherein somebody has worked in 2016 and received the payment in 2017, or worked pre-GST in 2017, received payment post-GST. There cannot be a single instance wherein the mismatch would not be there. I would humbly submit that, but that is also not an issue. Next, after the table, no response received from the RTP's end. So everything was blank from my end. Nothing happened. The matter is recommended to adjudication. So then they go for the adjudication under section 73 for further proceedings. An adjudication case ID was generated thereafter. Intimation under section 73 in DRC 01A issued on common portal. So what they do is they put it on the common portal on 7/9/23 with a date of reply on 14/9/23. But till date, no reply has been, again blank, because the RTP was not aware, therefore he didn't do nothing. But till date, no reply has been furnished by the RTP. It appears that the RTP has nothing to say regarding intimation of tax interest as certain under section 73 of DRC 01. Notice under section 73(1) SC1 was issued, where it was issued on the common portal with the date of reply by 18/10/2023. Reminder also issued. Reminder issued on 16/10/2023, such and such, where again in the common portal. No response received from the RTP. And therefore, notes an order has been passed, and the total liability here in Malheureable Fine is on the next page, including the penalty and everything. It amounts to 33,53,812. Now, if I can have my lordship for a moment on what the law on the subject is. Harin sabse pehle. I would be referring to the Madras High Court, and then I will come to the Rajasthan, and then subsequently to the Patna High Court also. Harin ka copy unko do. In this case, this Milord happens to be Harin Associates. The petitioner case has been referred to in paragraph 1 and 2. Respondent case has been referred to in paragraph 3. The court's observation is in paragraph 4 and order is in 5 and 6. Very small case. If I can have my lordship to begin with as to what the facts of the case is, para 1 and 2 first. An order in original dated such and such is assailed both on the ground of breach of principle of natural justice and on ground of non-application of mind. The petitioner has filed return under applicable GST enactment for the assessment period 17/18. Pursuant to so-called notice dated 7/8/2023, the impugned order was issued on 28/12/2023. Learned counsel for the petitioner submits that GST enactments came into force in 1/7/2017. Therefore, submits that the petitioner GSTR 1 statement, GSTR 3B, and annual return reflected the turnover from 1st of July 2017 to 31st of March 2018, because the period running from 1/1/17 to 36/2017 was a pre-GST period. So these are the Milord's contention. Paragraph 3 is Milord's what the respondent has to say. By referring to the impugned order, he points out that the principle of natural justice were complied with by issuing notices under Form ASMT 10, show cause notice dated such and such, and personal hearing notice were also issued to such and such. Now the court observes, on examining the impugned order, it is evident that tax liability was imposed on the petitioner on a difference between the turnover reflected in Form 26 AS and the turnover reflected in petitioner GST return. Learned counsel for the petitioner explained this difference by pointing out that during the period running from 1/1/2017 to such and such does not fall within the GST periods. Since the impugned order was issued without hearing the petitioner on this aspect, reconsideration is necessary, and what the court says. For reasons set out above, the impugned order dated such and such is set aside subject to the condition that the petitioner remits 10% of the disputed tax demand as agreed to within a period of 2 weeks from the date of receipt of the copy of this order. The petitioner is permitted to submit a reply to the show cause within the aforesaid period. Upon receipt of the petitioner's reply and upon being satisfied, the 10% disputed tax demand was received. The first respondent is directed to provide an opportunity of hearing, and the back attachment was raised. This is how it went. Although the court has dealt with it, I would still like to refer to a second judgment. And then we will come to the third judgment where the entire law has been let down. This, my lordship, happened to be the TVL Nagappa textile case. Herein, the petitioner contention is in para 4 and 5. The state or the revenue contention is in para 6. The court observation is in para 8 to 10. Similar cases, 2017-18, everything uploaded on the GST common portal for the petitioner to look into. Para 4 to start with. The learned counsel for the petitioner would submit that in his case, all notices, communications were uploaded by the respondent in the GST common portal. Since the petitioner was not aware of the said notices, they failed to file their reply within the time. Under these circumstances, the impugned order came to be passed by the respondent without providing any opportunity of personal hearing to the petitioner. Therefore, petition has been filed. Paragraph 6, what the respondent says. The respondent has uploaded the notices in the GST online portal, but the petitioner failed to avail the opportunity. Further, he has fairly admitted that no opportunity of personal hearing was provided to the petitioner prior to the passing of the impugned order. Therefore, he requested this court to remit the matter back to the respondent subject to such and such. Paragraph 8. In the case in hand, it is evident that the so-called notice was uploaded to the GST portal tab. According to the petitioner, he was not aware of the issuance of the said so-called notices issued through the GST portal, and the original of the said so-called notice was not furnished to him. In such circumstances, this court is of the view that the impugned assessment order came to be passed without affording any opportunity of personal hearing to the petitioner, confirming the proposals containing in the said so-called notice. No doubt, sending notice by uploading in portal is a sufficient service. Now, the law is being dealt with. Sufficient service. But the officer who is sending the repeated reminders, in spite of the fact that no response from the petitioner to the so-called notices, etc., the officer should have applied her mind and explored the possibility of sending notices by way of other modes prescribed in section 169 of the GST Act, which are also the valid mode of service under the Act. Otherwise, it will not be an effective service. Rather, it would only fulfill the empty formalities. Merely passing an ex parte order by fulfilling the empty formalities will not serve any useful purpose, and the same will only pave way for multiplicity of litigation. Then paragraph 10. There is no response from the taxpayer to the notice sent through a particular mode. The officer who is issuing notices should strictly explore the possibilities of sending notices through some other mode as prescribed in 169 of the Act, preferably by way of RPAD, that is a registered post with acknowledgement due, which would ultimately achieve the object of the GST Act. And therefore, thereafter the order has been passed. Accordingly, the court passes the following order. This also lays down the law a little bit, because the law, in fact, has been clarified by the Honorable Court in the third judgment, which happens to be the axiom gen. Herein, 140 writ petitions were clubbed together. 140 writ petitions. In some of them, appeal was preferred. In some of them, appeals were not preferred. In some of them, the period for appeal has already passed. Therefore, appeal would have been an empty formalities and everything. I would like to take my lordship to page 44 first. Internal page 44. And this will take some time because this is where the law has been let down. At page 44, Mullers will find that this is where the order begins. All the writ petitions have been filed challenging the respective ex parte assessment orders passed by the concerned assessing officers. Then the court observation, my lords, is from page 32 to 40. I am not bothering my lordship with each and every detail of each and every writ petition. Paragraph, my lords, 32 to 40 is important. Paragraph 32, my lords, will find is at page, internal page 81. Paragraph 32. Internal page 81 minutes. Therefore, for all these reasons, this court is unable to persuade with the submissions made by the petitioner that the uploading of the document in the common portal is not a sufficient service. It is a sufficient service. In majority of cases, the assessment order has been passed ex parte. The grievances of the petitioner was the due to following reason, and then there are different reasons why it could not be done. The aforesaid reasons are expressed by the assessee for not receiving the communication which were uploaded on the respondent in the common portal. In the impugned assessment orders, it has been reported by the respondent that they have uploaded in the common portal. However, no reply was filed by the petitioner, and in spite of the issuance of reminder notice for personal hearing, none of the petitioners have participated in the personal hearing before the respondent. Hence, it is clear that though no response were received for the so-called notice which were uploaded in the common portal, the respondents had continued to upload the reminder notices also in the same portal. Para 37. The respondents, being well aware of the fact that the mode of service adopted by them is not effective. So there is a difference between sufficient compliance and effective compliance. Them is not effective, but only sufficient in terms of section 169, has proceeded to pass ex parte assessment order. Normally, when a mode adopted by the respondent is not effective, they should have explored the possibilities by sending notices through the other modes of services as prescribed therein. There is no bar for the respondent to do so. When such being the case, this court is unable to understand as to why these assessing officers have repeatedly sent all notices reminders through ineffective mode of service. This court suspects the respondent this court expects the respondent to send notice via the mode of service which is sufficient as well as effective. In this case, there is no dispute on the aspect that the respondent issued the notices by adopting to the mode as prescribed in 169 1D of the GST Act. But being well aware of the fact that the mode of service adopted by them was not effective, they proceeded to pass ex parte assessment order, and they have not even made any attempt to send the notices by way of alternate mode of services. Once, if no response was received for the notices ASMT 10, DRC 01 or DRC 01 or A or whatever, which were etc., which were uploaded in the common portal by the respondents, at least they have to send the subsequent reminders by way of an RPAD. If any one notice is received by the assessee, he cannot make a plea that they were unaware of the notices which were uploaded in the common portal. Thus, this court suggests the respondent to at least send the subsequent reminders by virtue of RPAD prior to the passing of the assessment order, so that the precious time of the assessees as well as the officers could have been saved due to the failure on the part of the respondent to take such conscious decision while issuing notices and passing the assessment order. They made the assessee to knock the doors of this court by which the precious time of the court is paragraph 40. Second line. Therefore, this court is inclined to hold that the service affected by the respondent is sufficient but not effective. if the services of notices made by the respondents was sufficient as well as effective. For example, if they adopted the RPAD mode of service or any other mode as stated in section 169 of the GST Act, as stated above, the notices were deemed to be served on the assessees. If the assessee had not responded for the notices which were sent via RPAD or other modes, in addition to uploading in the common portal, the respondent shall proceed to pass ex parte orders, in which case the petitioner cannot take a stand that the ex parte assessment order has been passed in violation of the principles of natural justice. And therefore, paragraph 41 is there. For all these reasons, this court is inclined to set aside the ex parte assessment order. However, since the mode adopted by the respondent is sufficient mode, the petitioner had chances to view the portal and participate in the proceedings, but they failed to do so. Therefore, this court is of the view that the fault is on both the petitioner as well as the respondent, and thus this court is inclined to set aside the impugned order on the following terms, and therefore thereafter the terms are there. At the end of the day, the order impugned, my lords, is an ex parte order. How did I came to learn about it? I was informed by my banker that the bank account is put under freeze. No prejudice would be caused. In fact, the revenue can earn more if I am given an opportunity of hearing, because then I will come with every document. They have a chance to earn more also. That is all that I have to say.
This 10% was deposited
My lordship,
in
there are three things. One is 2017-18 period. Some of it pre-GST, some of it post-GST. Second is I was under a temporary ID. In temporary ID, I voluntarily made the payment. There could be discrepancy because of that also. Today, I do not know what the discrepancy is. No document is there with me. And the third and the most important thing, Minors, is that even if the work was done pre-GST and the payment was done post-GST, then also discrepancy would be there. Because previously it was a VAT period. So any payment that I have received from the department, I do not know whether it was 12% GST, whether it was 18% GST, or whether it was a VAT.
With regard to section 169, the provision is very clear, ma'am. It says any decision, order, summon, notice, or other communication under this act or the rules made thereunder shall be served by any one of the following methods, namely such and such. Our is covered by making it available on the common portal. Now, our coordinate bench has dealt with this question, madam, and have clearly held that if any one mode is adopted, that is a sufficient service, madam. This, I have a soft copy of this.
You don't have a printer? See, the point is not, nobody is saying that it is not sufficient.
My lord.
In all the judgments, the court says it is sufficient, but not effective. The word which is being used is effective. The court says that you have served them, but it has not served the useful purpose. Since it is not effective, the opportunity has not been given to the assessee or whatever they call it to come back, file a reply. And that is the reason it's a mere formality. All the courts have held under 169. Any mode of service, one is effective.
Yes, ma'am.
Is not, it's service. It is deemed to be service, but not effective service. And if it is not effective service, then the opportunity should be given to the assessee to come back and plead his case.
And I have a judgment of High Court of Madras, madam. And
here, there's another factor which is there, it's pre-GST tenure.
That also is covered by our division bench, ma'am. This is another judgment. This, my lord. Page 32, ma'am.
Page 32.
Yes, ma'am. 5.23.
Nobody is disputing this fact.
My lord.
None of the judgments also disputed this fact.
But my lord is
That
saying it is not
putting
an
it
effective service.
Effective.
My lord.
That's
But
what it says.
Yes, my lord, but this judgment says that if it is served on the common.
It is service.
It
All
is a
other
service.
judgments also say, none of
My
his
lord, my
judgments
lord.
says it is not service.
But it was not brought in his.
It is not effective service. That is the distinction which the courts have drawn.
Mhm.
They're not saying it is not service.
My lord.
All the judgment he has also relied upon, they are saying that under 169,
Mhm.
putting it on the portal is service.
My lord.
It is not effective service.
My lord.
When a department is dealing with the assessee, it should ensure that the service is an effective service. So that
So
they
when
can
he's
come,
filing
they
returns,
can come forward and file their reply, and then you pass an order. So ex parte orders are absolutely, that is not the way it should be dealt with when it comes to the government. All right, that's exactly what the intention of the judgments are,
My
that you should give an opportunity.
My lord. Opportunity should be given if there is a show cause notice, my lord. The show cause notice before passing
Madam,
any
show-
order.
That's what they are
My lord,
saying,
my lord.
that it is not effective. You have given them show cause notice, you have given a reminder, you have given a hearing. It is not effective.
It is not effective, but he is filing returns, my lord. He is supposed to.
He is filing, this is also
Quoted
you have
my
to
lord.
understand, it is pre-GST era. And then subsequently it is GST era. So you should have taken more precaution. Let him be relegated back. Show me the other, this one.
My lord, I kindly make it not today, my lord. I will show something else, my lord. On that point, my lord
I'm
can
convinced
relegate. My lord, I know
he
that.
has to be relegated back.
My lord.
Has to be relegated.
She knows everything. It is not that doesn't know it. She used to be an innocent soul. But nowadays, because of the company she keeps, she has started to take malicious pleasure in the retribution.
I see the change.
Yeah.
I see the change.
Yes. She has started taking malicious pleasure in the writ petitioner's
She
claim.
was the first one who would say, yes, yes, it can be relegated
Yes,
back.
yes.
Let it be.
There is
She
a
used to be
point,
an
my
innocent
lord.
soul.
That is why I'm saying. He did not take that
She is
point.
losing the shine now.
He did not take the point.
Now you have
That is the
become a
point.
seasoned lawyer.
I'm saying, my lord, what has happened, the show cause notice which was given to him, no, in that there was no date for personal hearing, and he did not take that point.
That's all right.
And
but
so without.
I do not have a copy of the
So we
so notice. How
we
will
can
I take that
delegate it
point?
back.
My lord.
We-
But I want, my lord, if your lordship wants to delegate it back, on that point, that is a settled principle, my lord, not on 169, my lord. It is.
I'm not sending it back on 169.
Oh, my lord.
I'm sending it back on the fact that it was a pre-GST era. He was not given the opportunity.
But
So I'm
in
saying-
with regard to pre-GST era, the division bench has held, like, even if he's not an unregistered person, my lord, like if he makes the payment, he can take the payment from.
Section 22 says
Section
22 unregistered holo liability থাকবে
হ্যাঁ,
section 9.
absolutely. Even if he's an unregistered person, he's liable to pay
That's
the.
what he was paying there.
My lord.
It's not that he was not paying. Maybe it was not sufficient
With
according
regard
to.
this pre-GST era, my lord, I have the division bench. If your lordship wants to see.
ছেড়ে দিয়েছে।
Well, if your lordship wants to send it back, my lord.
I'm just
send
sending it back without
And
any
send on
observation.
the issue of that, he was not given a proper show cause notice. And without giving a proper show cause notice, adjudication.
I do not have a copy of the show cause notice. I haven't filed it with the writ petition because I do not have a copy.
বললাম সাবমিট করেছে আমাকে তো দেখতে হবে This
All
is my
right, take
instruction.
The petitioner in the present writ petition has challenged the order dated. This is 12/12/2023.
Yes, my lord.
Has challenged the order dated 27/2/2026. No, this is 12/12, right?
12/12/2023.
12/12/2022. Passed by the Assistant Commissioner of Revenue. Assistant Commissioner of Revenue, Jalpaiguri charge. Under section 73(9) of the WB, GST and CGST Act 2017. As also the consequential recovery proceedings initiated by the respondents, including the garnishing notices dated 23/2/2026 and 26/2/2026. Full stop. Learned counsel appearing for the petitioner submits that the petitioner is engaged in the business of construction and was granted GST registration on 31/1/2019, right? 31/1/2019, full stop. It is contended that An intimation in the form of DRC 01A dated 7/9/2023 was issued for the tax period July 2017 to March 2018, alleging discrepancies between the turnover reflected in the form 26 AS and the outward supplies declared in GSTR1. It is further submitted that the show cause notice dated 19/9/2023 was issued through the GST portal, followed by a reminder dated 16/10/2023 on the said portal. Full stop. Admittedly, no reply was filed by the petitioner, and consequently, an ex parte adjudication order dated 12/12/2023 came to be passed under section 73(9) of the said act, confirming the demand of rupees 3353812. Full stop. Learned counsel for the petitioner, however, contends that the impugned demand pertains to a period prior to the GST registration of the petitioner, and as such, the very initiation of the proceedings is without jurisdiction.
I was working then on provisional I.
And that he was working on the provisional
GST IN.
Full stop. It is further submitted that without affording adequate opportunity, the order has been passed ex parte and coercive recovery proceedings have been initiated, including initiation of issuance of garnishee notice and freezing of the bank account, thereby causing grave prejudice to the
And they have also written a letter to my
No, third party
My
garnishee
employer.
proceeding is initiated, my lord.
by
They have-
WBSCDCL.
I have noted both the letters. Full stop. Thereby causing grave prejudice to the petitioner. Full stop. Learned counsel for the petitioner has relied on the judgment of the Honorable Madras High Court in WP 15691 of 2024 and WMP number 17100 to 17102 of 2024. Dated 24/6/2024 to impress upon the fact that the tax liability which was imposed on the petitioner on the difference between the turnover reflected in Form 26 AS and turnover reflected in the petitioner's GST return does not fall within the GST period. Full stop. Since the impugned order was issued without hearing the petitioner on this aspect, reconsideration is necessary by putting the petitioner on terms with regard to the default in responding to the show cause notice or participating in the proceedings. क्या लिखा है शुरू से थोड़ा बता देना. He has relied. So the counsel for the petitioner states that in the said judgment, the impugned order was set aside and the petitioner was granted the liberty to reply to the show cause notice and was provided an reasonable opportunity of personal hearing. And thereafter, the adjudicating authority was directed to issue fresh orders. Full stop. You'll deposit some money?
Yes, 10%.
The petitioner is ready and willing to deposit 10% of the disputed tax amount. Full stop. Keeping in mind keeping in mind that the petitioner, though has been served notice under section 169(1), 169(1) of the said act, the said notice is not an effective notice since the notice has been served, but the same is not effective to the extent that the petitioner was unable to respond to the said notice, and that no opportunity was given to the petitioner to file his response to the said notice. Though the act itself states that any of the modes the petitioner can be served, and that will be considered to be duly served notice. But the notice is not effective if the petitioner has not been granted the opportunity of replying or being heard. And since in the particular facts of this case, the petitioner had started his business prior to the GST era, and that he had been voluntarily depositing the taxes prior to the GST era, and that the discrepancy in the tax demand is prior to the GST era, the petitioner shall be given an opportunity of hearing, subject to the condition that the petitioner remits 10% of the disputed tax within a period of 2 weeks from the receipt of the copy of this order. The petitioner is further permitted to submit a reply to the show cause notice within the aforesaid period. Full stop. Upon receipt of the petitioner's reply and upon being satisfied that 10% of the disputed tax demand was received, the respondent number 1 is directed to provide a reasonable opportunity to the petitioner, including a personal hearing, and thereafter issue a fresh order within a period of 3 months from the receipt of the petitioner's reply. Full stop. On account of the assessment order being set aside, the bank attachment is raised. The writ petition is disposed of on the above terms without any order as to cost. What submission? Forget that. I'm not going against your.
Wait.
Not going against your.
I'm not the letter at page 44. The one
I've also held that it's an effective service. It is service. Yes. With the emphasis, right? उसमें एक वहाँ जहाँ लिखा है ना, the impugned order dated so and so, it's set aside. शुरू में लिखा है
December 2023.
12th December 2020.
And subsequent.
And the subsequent guy. That I've taken care in the last time. Impugned demand is set aside.
Before IC, may I just mention one matter, my lord? That matter can be listed on Tuesday. 2025 we have filed a petition.
Old matter is not right.
Mine is 2025 matter.
25 we are already here, 25, 26.
It's a small matter, only pilot has passed many orders.
What is this?
This is a GST matter. We are challenging the adjudication order on the ground that it was notice and order is uploaded in the tab portal, different tab, so that petitioner could not see that.
This will be flooding. Wait. Okay. Any other? Password or not? All out the pass.
Item
Somebody
number
is here in the password. Yes, call out the password.
item number 17.
Yes.
Actually completed. Kindly post the matter for the next week.
Wednesday.
I'm grateful.
Wednesday.
Item number 18.
Being pushed for possible.
Tuesday. Why Passover? After lunch, keep it after lunch.
Good for you,
After
Lordship.
lunch, keep it after.
Item number 8.
18 18টা করে দিই তারপরে একটা বাকি আছে আইটেম নাম্বার 18 একটা বাকি
I'm sorry, my lord. The earlier
My lord, item number 18, I am appearing on behalf of the Siliguri Municipal Corporation, my lord.
On the last occasion,
Mr. Das, where are you?
My lord, I am very sorry, my lord. I am appearing in the virtual mode, my lord.
Why?
My lord, I am suffering from high fever, my lord, because of the seasonal change.
Oh.
Hence, I did not come to court, my lord.
All right.
my lord, this. So Lordship kindly recalls, this is the case, my lord, where my business has not been allowed to be started by the municipal commission because, my lord, on the alleged ground that I have not been able to produce the sanction plan. Now, I am a lessee in respect of that property, my lord. And I was given a trade license by the Siliguri Municipal Corporation. Even the Siliguri Jalpaiguri Development Authority, my lord, had granted a land use compatibility certificate in my favor, converting it to commercial as well as residential building. Now, being aggrieved by the last order, impugned order, by which, my lord, my business has not been able to allowed to be started on the basis of non-production of sanction plan, the petitioner is before your lordship, my lord. Now, the sanction plan is not with me. Now, what from the documents I could get from my landlord, my lord, it is not with them. They had also lodged a police complaint. And if your lordship kindly takes up the order impugned, which starts at page 58.
Page 58.
Yes, my lord. I'll, my lord, request your lordship to come to page 59. My lord is.
Yes, 59.
59, may I place it, my lord? Accordingly, Shailesh Kumar Jha was asked whether the designated place where the restaurant is to be constructed is residential or commercial, but no definite answer was offered. No deviation has been pointed out in the inspection report. It is in such situation the owner of the building, namely Sri Tarakasya Prasad Gupta, who is the private respondent before your lordship, and Rajendra Gupta by a notice dated so and so were called for hearing on 12th of February 2026. Despite service of notice, neither Sri Tarakasya Prasad Gupta nor Rajendra Gupta appeared for hearing on the scheduled date. From the records of the case, it appears that Sri Tarakasya Prasad Gupta made an application for obtaining a certified copy of the building plan. The building plan could not be traced out. It is not even there with them. In the aforesaid facts and circumstances, since it could not be ascertained as to whether the designated place is residential or commercial, hence no permission can be granted to Shailesh Kumar Jha to carry out his business of restaurant cum bar. Further, the concerned parties are hereby directed to stop all construction renovation activities immediately, my lord. Now, I don't have, admittedly, I cannot have the sanction plan. The landlord does not have, the corporation does not have. And the
How come the corporation doesn't have? Who's
That-
for the corporation?
My lord, I am appearing
Yes,
for the corporation. My lord, the fact remains that the plan was
Who has
sanctioned in
sanctioned
the
the
year
plan?
2001. My lord, Siliguri Municipal Corporation had sanctioned the plan, my lord. My lord, there is no doubt regarding that. We are aware of the fact that we have sanctioned the plan. But my lord, this plan was sanctioned in the year 2001. My lord, later was a general ID was lost in the year 2023. thereby stating that the plan was misplaced. And in the year 2025,
General diary was, wait a minute, Mr. Das, general diary was lodged by the landlord, right?
Yes, my lord, yes.
Yes,
Not
my
by
lord.
you.
Yes.
Where's the plan? We are talking about you.
Yes, my lord. My lord, to be very honest enough, my lord, on the last occasion, we had sought some time in order to get some instructions from the authorities so that as to what is the fate of the plan, because in the order they have clearly stated that the plan cannot be traced out, my lord. Hence, my lord, some more time is
Come
required.
with the report.
Uh,
Come with the report, or the commissioner should be here to explain how the plans are getting, why the plan is not coming forward. What kind of an innocuous
my lord.
order has been passed?
My lord, I accept
What
that.
kind of
I accept
innocuous
that. I
orders
bow
have been
down.
passed? Who
My lord, I
will
bow
decide?
down to your lord.
Who will decide all this?
No, my lord. It's
You
the
tell the
duty of-
commissioner, either I call him here, what kind of order is this passed? Non-application of mine? If the landlord doesn't have a plan, you don't have a plan. Who is the sanctioning authority? You are the sanctioning
My lord,
authority.
the Jalpaiguri Municipal Court.
Then where is the plan?
I bow. My lord.
And who will tell which property is to be used for what purpose? The landlord will decide this. What kind of order has been passed by him?
My lord, my lord, may I suggest one thing before your lordship, my lord? May I have the
Yes.
permission to suggest? My lord, let this impugned order be set aside. May a detailed order stating the reasons be passed within an interaction period as fixed by your lordship. My lord, let that order be passed. Let this order, this is absolutely cannot be in the eye of law, it cannot be allowed, my lord. I state that, my lord.
I'll record your submission.
My lord, kindly to my lord. My lord, kindly.
No, sir, I'll record your
My lord.
submission.
My lord, as an officer of the court, I have made this submission, my lord.
Then,
Kindly
Mr.
to-
Das, you come up with the report. Come up with the report, file a report. Then I'll set it aside. File a report.
My lord, I shall.
Who will decide the property is to be used as commercial or residential? You will decide.
My lord, Jalpaiguri Municipal Corporation, the commissioner will decide, my lord.
Then, why is the commissioner saying that I don't know what has to be done? Accordingly, Sailesh Kumar Jha was asked whether the designated place where the restaurant is to be constructed is residential, commercial, but no definite answer was offered. What does he mean by that?
My lord. See my humble submission for my lord. Set aside this order.
He's the relevant
Kindly
authority.
provide
He's the
The
relevant
commissioner,
authority.
the commissioner.
with a reason, with a detailed recent order, and then, my lord, let that opportunity be provided, my lord. That's all, my lord.
The petition, the present writ petition, has challenged the order dated 27/2/2026 issued by the Commissioner, Siliguri Municipal Corporation, who has declined to grant permission to the petitioner to run a restaurant cum bar from the third floor of an existing 4-storied building situated at Hill Cart Road near Sevok Moor, Siliguri. The said refusal is primarily on the ground that no sanctioned building plan is available with the petitioner, and therefore the authority is unable to ascertain whether the building is commercial or residential in nature. The petitioner is also directed to stop all ongoing construction activities in the said premises. Full stop. The order further records that the commissioner is unaware if the designated place is constructed as residential or commercial, since the petitioner is unable to provide any definite answer. Full stop. Learned counsel for the respondent. Should I record?
My lord, kindly, my lord, don't record.
Learned, is there any representation made by you?
No, this is challenging the order, my lord.
Learned counsel for the respondent states that due to insufficient information on the ground that the sanction plan was not available with the petitioner, the said impugn order had been passed. He further states that the aspect whether any commercial activity can be carried on at the said site can also be ascertained from the sanctioned building plan. Full stop. Learned counsel for the petitioner had drawn the attention of this court to the fact that he is a lessee and that the landlord had lost the said sanction plan, for which a general direct has already been lodged by the landlord before the concerned police station. Full stop. The after considering the argument advanced by the counsel for the party and on perusal of the materials on record, this court is astonished to note that the commissioner, who is the custodian, the commissioner who works for gains at the Siliguri Municipal Corporation and is the custodian of all sanctioned building plan, passes an order without making any inquiries to the fact whether the said building plan is lying with the department. Full stop. Since the Siliguri Municipal Corporation is the building sanctioning authority, the commissioner has not taken any efforts to locate the said plan and pass an order as to whether any commercial activity can be carried out by the petitioner from the said building or not. Full stop. It is evident from records that a building plan being number 10419 dated 15/10/2001 admittedly has been sanctioned by the Siliguri Municipal Corporation. Full stop. The impugn order nowhere records that any steps were taken by the commissioner to verify the said fact. Full stop. It is further noted that the corporation, being the authority to designate any area to be commercial or residential in accordance with the layout plan, has rather noted that in the absence of the building plan, the commissioner is unable to ascertain whether the said building can be used for commercial or residential purposes. The reading of the impugned order shows absolute non-application of mind by the Commissioner, Siliguri Municipal Corporation, who has completely failed to discharge his duty while passing the impugned order and has put the onus on the petitioner to provide him with the sanctioned building plan, and even to the extent whether the said building can be used commercially or not, to be answered by the petitioner. Full stop. The impugned order is set aside. The Commissioner, Siliguri Municipal Corporation, is directed to pass a fresh order in terms of, this would be in terms of WPA number 2437, right?
Yes, madam.
In terms
My
of
lord.
WPA number 247 of 2025, wherein the observations of this court shall be kept in mind within a period of 8 weeks. 8 weeks?
My lord, elections are there. Can it be 10 weeks, my lord? Can
Within a
it be
period
10
of 12 weeks. Within a period of 12 weeks from the date of communication of this order. Election. From the date of communication of this order.
Deeply
With the aforesaid direction, the present petition is disposed of.
My lord, may I file the affidavit also?
Affidavit of.
My lord, I am appearing for this one number 5 and 6 with Mr. Deputy Dhar.
Great.
Item number 8.
Here is the corrected order. And my lord,
Item 8, then for the board minutes, it's only minutes. Can you record 1 minute sentence minutes that appeal is pending?
Take down. The petitioner has filed the present petition challenging the order dated.
Well, there is no such order from the DPS. Well, they have only started the A category.
The petitioner has filed the present writ petition seeking writ of mandamus, directing the respondent authorities herein to grant A, inverted comma, category scale of pay to the petitioner, being the primary school teacher, on or from their date of completion of the course from 16/3/2019 instead of from 16/3, from the date of completion of this course, i.e. 16/3/2019 instead of 26/8/2022, and disperse the arrears along with interest at the rate of 12% per annum. Full stop. The petitioner has drawn the attention of this court. So give me the orders.
Okay. Page 39.
The petitioner has drawn the attention of this court to the order passed by the coordinate bench of this court in WPA number 28842 of 2023, dated 8/4/2024, wherein similar reliefs were sought by the petitioner. Full stop. The coordinate bench of this court, by its order dated 8/4/2024, had allowed the writ petition of the petitioners. Full stop. He has further drawn the attention of this court to another judgment passed by the coordinate bench of this court in WPA number 16023 of 2024, dated 19/7/2024, to buttress his argument that similar reliefs had been granted to the petitioner in the above mentioned petition. Full stop. Keeping in mind the directions passed by this court, keeping in mind the directions passed by the coordinate benches of this court, the present petition of the petitioner is allowed. The petitioner, this court directs the petitioner shall be granted A category pay scale after the last date of examination, 17th March 2019, full stop. Let the arrears be paid to the petitioner within a period of 2 months from date. With the aforesaid direction, the instant writ petition stands disposed of. There will be no order as to cost. All parties are directed to act on the server copy of this duly downloaded from the official website of this. उससे पहले एक लाइन लिख देना. Learned counsel for the respondent board states that this court acknowledges the fact that this court in various other writ petitions have passed similar directions, though he further states that the said directions have been challenged before the division bench, but no stay has been obtained in any of the petitions. Full stop. उसके बाद कर देना, keeping in mind. Yes. Rate arrears be paid. There's no rate of interest which I have. Has any of the court decided?
No, there is no such decided.
Yes. 17/3, right?
Malur, 7.
How many matters?
Malur, 8 to 15.
8 to 15.
Total 8 matters. Malur, only the date of result has been changed. Your lordship are directing the A category payment of scale from the last date of examination instead of 26/8. That date should
Then
be.
give the dates in all the matters.
I will.
Give the dates.
I will.
In this date, this is fine.
Yes.
17 is fine.
Yes. Now 17/3/2019 is the same.
Right.
Thereafter, instead of the date, that is the different, because my lord, all different matters, the date of my lord, the result is publishing the result is different.
So you have to give that.
My lord, I will give.
Give the date.
My lord.
From the date of completion of the course, that is 16/3/2019.
In this case, what is the date of examination?
My lord, 16/8/2022.
So from 17, it has to be given.
Yes.
Right? 16/3, right?
Yes, ma'am. 16/3/2000, the last date of examination.
Yes.
We are paying for area from the 17/3/2019.
So this is fine. 17/3 is
It is-
fine.
it is
In the
fine.
next matter,
In the next matter, my lord.
Item
that
number
is
9.
Item number 9. My lord, 17/3 date is for all the matter is same. Your lordship are directed instead of that is the date of the publishing of result. That is the difference.
I have only directed that arrears will be paid.
Yes.
Let the arrears be paid. I have not given any date.
No, my lord. Your lordship not given any date. Your lordship are directing as per the kind of my lord prayer. That is a completion of the course from 16/3 instead of the date 16/8. That is the difference.
So in that case, I will not give any date. Na. Give me the order. एक वो जो draft order दिया था ना दोनों.
Or my lord, let it be a date of printed. Publishing the result.
ऊपर वो change कर दो सुनो ना. The petitioner challenges first paragraph. The petitioner challenges the inaction of the district primary school from denying A category pay scale to the petitioner from the last date of examination.
That's sufficient.
उसका एक paragraph और add कर दो. It is now well settled that a person is deemed to have qualified from the last date of examination In the event they succeed the same. Full stop. उसके बाद कर देना, in those circumstances, this court directs that the petitioner be granted a category pay scale after the last date of examination. Full stop. Let the arrears be paid, so and so. उसके बाद कर देना, the respondent says state so and so. इसके बाद करना, this court जो हाँ arrears. Yes, for all. Extreme cases.
Item 9. 9.
Yes. Any other matter?
Item number 10.
Draft order, ना? Draft order मिलेगा.
ওইটা তো যদি আপনি draft করেন। ঠিক আছে।
10, done. 11.
Item number 11.
Same. Give your opinion.
Yes, sir.
ঠিক আছে।
You're appearing for the board in all.
বোর্ডের নাম দিয়েছো?
12.
Which one?
I also corrected the name of the DPSC council also.
13. 14. 15.
'Done.
Good.
All matters.
Extreme good.
There is. But
There is something going on in the corridor.
the moon was not sighted in.
In the evening, it will be visible. Very confusing.
Yes. Yes. Stop.